Check 1, 2.
Are we ready? Are we ready? Good morning. The November 17th, 2022 hearing for the Planning and Land Development Regulatory Commission is now called to order. Would everyone please silence your phones and stand for the pledge, please? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. I would like to thank everyone this morning for joining us. There are forms in the rear of the chambers for anyone wishing to speak on any of the cases that's being heard today. Ms. Tucker, may I have a roll call, please?
Member Feller?
Here.
Member Young?
Present.
Member Shelley?
Here.
Member Bender?
Here.
Member Costa?
Here.
Member Sixma?
Here.
Chair Mills absent.
Thank you. We don't have any minutes to consider today. If you are participating, we will hold you to a 3-minute time limit this morning on your comments. That's for anyone that's speaking on the issues other than the applicant. After the comments have been heard, I will give the applicant an opportunity to address any concerns the speaker may have and answer any questions the commissioners may have. Mr. Storer, would you please give legal comments?
Yes, thank you, Mr. Chair. I think Chair Pro Tempore. This is for the benefit of the public and for the applicants and for the commission members that decisions by this body on special exception cases and cases which rezone real property from one classification to another pursuant to the zoning ordinances are recommendations only to the county council and do not constitute a final hearing. So new evidence may be introduced at the county council public hearing. Decisions on variances made by this body constitute a final action subject to an appeal to county council. So what this means is that no new evidence may be presented at the time of the county council public hearing on the appeal. An aggrieved party that appeals such a decision is confined to the record made before this body. Hearings by this body on rezoning, special exceptions, and variances are quasi-judicial in nature, meaning that this body is acting more like a court and must take into account all oral, written, or demonstrative evidence presented. Their decisions on these cases must be based on competent substantial evidence in the record, and competent substantial evidence has been defined as that evidence a reasonable mind would accept to support a conclusion. Thank you, Mr. Chair.
Thank you. Following legal comments, I would like to ask the commissioners to disclose for the record any ex parte communications that have been, that have occurred before this public hearing, that a vote is to be taken on any quasi judicial matter. Mr. Feller?
I do. On the two water ordinances, Mr. Soria, those would need to be disclosed as well too, correct?
No,
on the
those
water.
are, if you're talking about the CPAs, the comprehensive
Yes.
plan amendments, those are legislative decisions and not quasi judicial. You do not need to disclose ex parte communications.
All right, thank you. Then the only ex parte I have is Wendy Anderson, and it is with case PUD 23-002.
Can
Is
you,
that another one?
can you state if whether it was the general topics of the conversation? Was there opposition? Approval?
Actually, it was in support of the, those, but with a few concerns.
So this is PUD 23002.
23-002.
Okay.
And again, that was Wendy Anderson from DeLand.
Mr. Young?
None.
Ms. Shelley?
None.
Mr. Costa?
Yes, I had a brief conversation with Mr. Posey on Z-22140, just getting some background.
Mr. Sixma?
None.
And I had a conversation with Mr. Paisley on case number V23-007. He's the applicant. Ms. Smith, do we have any items to be continued or withdrawn today?
No, sir.
Mr. Chair, if I may, I'd
Mr. Costa.
like to make a motion that we continue case CPA-21-012, since we have a resident expert on the sewer systems here on our board, and he is not present until the January meeting.
Okay, you want to put that in the form of a motion, please?
I'd like to make a motion that we continue case number CPA-21-012 until the January PLDRC meeting, January 2023.
I would second that.
It's been moved and seconded that we put CPA 21-012 of the sanitary sewer element until a date certain of, you thinking January?
Yeah,
January?
yeah, the January meeting should be fine. I just
Do
don't
you
know
have
what
what that date is?
It would be
January 19th.
Okay, so we want to continue this to January 19th, this element. All in favor?
Aye.
Opposed? Motion carries unanimously. We have one item of old business. Ms. Shelley, would you read that case for us, please?
Yes, sir. Case number V-23-004, variances to separate non-conforming lots and to the dock and boathouse regulations on a transitional agriculture A3 and prime agriculture A1 zoned property.
May we have the staff report?
Good morning, Michael Hansen, Planning Development Services. This variance has two variance requests. The first one is for the separation of non-conforming lots. The subject parcel is approximately 5.25 acres. It is split zone with a portion that is A1 and a large portion is A3. It was broken off in 2000 from a larger parent parcel that has common ownership with the two adjacent properties that you can see on the screen for the variance site plan. The applicant owns a large portion of land to the west of this property, is intending to combine it with his other property. There's been conversation that this has to happen as far as the separation of non-conforming lots in order for him to be able to combine the lots with his other properties to give him an overall parcel of approximately 69 acres. Staff, when evaluating the criteria for granting said variance, determined that this particular variance request met all 5 of the criteria for granting said variance. Variance request 2 is for an after-the-fact dock that was created without permit. It exceeds the maximum dock size of 750 square feet per section 72-278 by 402 square feet, bringing it to a total size of 1,152 square feet. In evaluation of the criteria for granting this variance, staff made the determination that it met 0 of the 5 criteria for granting said variance, and has a recommendation for denial on variance request 2, noting that there's no hardship that preempts the need for the dock exceeding the maximum dock size per the section for the zoning ordinance. There are a couple or 2 conditions, should the PLDRC find that the variances need to be granted, in that it's limited to, obviously, the dimensions as depicted on the variance site plan, and because of the after-the-fact violation, a wetland alteration permit's necessary to alleviate environmental code violations, and a site restoration plan will be required as well. I'm available for any questions the PLDRC may have.
Do we have any questions for staff? Would the applicant please come forward, give your name and address for the record, please?
Good morning. My name is John Alabin, owner of the property.
Okay, would you tell the commission your address?
Pardon me?
Your address.
Okay, 320 Privat Road in Seville.
All right, thank you. Would you tell the commission anything that you would like them to know about what they're going to vote on today, if it's anything other than what staff has already given us?
So I did write a report back to, as you guys requested. I'm a contractor for a living. I follow the law. I believe very much so in doing so. Back in 2001, I had some health issues, and I'm not blaming it all on my health issues, but sometimes you have to take a break in life and just kind of, I had treatment for several months following that when we found out what I had, and we decided to go ahead and build a dock. You know, I hired some guys to do the dock, subcontractors, and we, you know, we have dreams in life. Hey, we like to, it's nice to have a little John boat back in there, and we went over, we didn't read the rules and regulations. We went to 1,157 square feet instead of the 750 square feet that we should have built. When we purchased the lot back in, when we purchased the land back in 2020, it was shared to me that it's agriculture. I could build a pole barn. I could build, as long as you don't build a dwelling, you'll be okay. And I kind of ran with that. So I'm not blaming anybody. You know, I should have get a little bit more educated on it, but I did what I did. You know, so I'm just asking for some help to keep the dock there so we could continue enjoying it. And if you guys ever go down to Seville, it's quite a beautiful dock. So, and I don't think it's hurting anybody around us, unless anybody has any objection.
Do we have any questions for the applicant?
I do, I have a few questions.
Mr. Fellow?
You bought in 2020 or 2001, I'm sorry, was it?
No, we purchased the property in 2020,
Okay.
July.
And do you have an ag exemption on the property, or did you just think it was ag
No, we do.
property? So you have an ag exemption?
Correct.
So you are able to build without permits on non-residential structures? So that answers that question for me there, but you built over the size.
Yeah, we did.
It'll come back to staff on that question on why he's being required for permits, I guess.
That applies to non-residential farm buildings.
Farm
on a
buildings.
farm.
Okay, so that's only for farm buildings?
Yes, they would have to, I mean, yeah, you'd have to kind of relate the structures that you're building to the agricultural classification or exemption that you receive from the property
All right,
appraiser.
and I'm learning as we go on some of these things too, but
I am too.
as a contractor, you didn't, I mean, I would think that with the wetlands and everything else, there would be some understanding that it's probably not just digging holes in the wetland area. Did any of that come into play? I just out of curiosity, I mean, I know we all like our piece of paradise, but then when we start
So
boring holes into it.
You know, when I purchased this piece of property in 2020, didn't look the way it looked today. You know, I always believe in buying a piece of property and beautifying it for myself, my family, and also for our neighbors. And that's what I created there. If you would have seen that piece of property before we purchased it, no, I think you guys would be proud of what we've done out there. So yes, we didn't follow the rules. We went oversized, but you know, that's where we're asking for some help today.
My only other question for you is, it was noted that you owned another piece of property that you want to join this one to?
We just purchased another 13.76
Is that
on the west side of us.
To the west side, so you own that large parcel to the
Yeah,
west side
and
as
we,
well,
what
too?
we want to continue doing is raise cattle in that area.
So you intend to keep that ag? Okay, that's all my questions for now. Thank you so
Thank you.
much.
Mr. Young?
Well, he answered part of my question. I'm just perplexed that if you were a contractor, you didn't think you needed a permit for a dock, particularly a dock, because it's over water control, and that's my only comment about it. I'm perplexed a little bit that you wouldn't have checked on that.
Yep.
Something I might say is I've seen the property before. It's totally changed. You did a great job with it out there. Because, I mean, this property's stuck out in the middle of nowhere out there. You like to have GPS even to get to it, but you did a good job with it.
Thank you.
So.
Anyone else?
I guess my only final question would be, there were some conditions put on this, environmental permitting and doing some you know, or you have no problem with any of those conditions?
No, no,
if
we
were
already,
set?
it's all enrolled already.
Okay, and do you know how many feet of water line you have? Do you know about how much it is?
And then lineal feet,
Linear feet of water frontage, just out of curiosity.
so on Lake, we're about 630, but we're able to use pretty much about 225 feet of it.
Okay.
All right, if there are no other questions for the applicant?
And that's a real small so-called lake. How big is that lake?
I'm going to say probably a 70-acre lake.
70 acres, and there's how many households around it? Not many.
No,
Yeah,
there's a couple of trailers, and I'm going to say 5,
yeah.
maybe.
So basically small, and there's no public access whatsoever.
Correct, no.
Yeah. All right.
Thank you, sir. We're going to open it up for the floor and see if there's anyone that has a concern.
Okay.
Want to come forward? If so, we will give you an opportunity to come back and rebut whatever, if necessary.
Okay.
Thank you.
You want me to sit down?
Yes, please.
Okay.
Is there anyone in the audience here today that would like to speak for or against this case? If not, we're going to close the public hearing. Excuse me? You want to speak to this case that we're talking about right now? Does that pertain to this case that we're doing right now? Okay. If it's not this case, when we get to that case, then we'll open up the floor and do the same exercise we're doing right now. Yes, sir. You want to, would you come up to the mic, please? Give your name and address for the record, please.
My name is Ed Sinez from Orange City, West Lake Helen. I've known John for years, done a lot of construction with him. It's always been above board. I know that he had this property when he wasn't doing good, and this was his domain to go rehab. And I'm sure if I owned property on that big of a lake that was all private, I'd probably do the same thing, to be honest with you. But I don't think he did anything intentionally or try to get away from the, Wetlands Act or anything like that. It's always been above board with him. I just wanted to share that, because I'm here for another case, not with John.
Okay, Mr. Sinez, will you fill out the form in the very back, please?
I did one for another one.
I need it for this case and
Okay.
give it to the staff.
I'll do it.
Thank you. Okay, anyone else? Okay, we're going to close the public hearing and open up for commission comments or a motion, please.
I have a quick question for staff, please.
Mr.
Yeah.
Costa.
Mr. Hanson, on your recommendations, number 2, you're asking for a wetland alteration permit. Do we know, in fact, that the wetlands were impacted? Were there surveys submitted with there's no surveys, there was nothing submitted to the county as far as a permit is concerned, so we don't have that information, correct?
So the wetland alteration permit request was made by our environmental permitting staff.
Okay.
So that will be handled during the building permitting. So after the variance potentially is granted, the applicant will have to contact building permitting to apply for a building permit, and during that process, the wetland alteration.
They'll
permit
have to
will be
submit
handled.
the full survey as well as a wetland survey for
Yes,
the
sir.
property. Okay, that's what I was confused about. Thank you.
The floor is open for a motion.
I'm ready to make a motion, case B 23004. My motion would be for approval with the staff recommendations.
I'd second that.
It's been moved and seconded for approval of case B 28004. All for it signify by saying aye. Aye. Any opposed?
No.
There is 5 to 1 in favor with Ms. Shelley voting no. Thank you. Ms. Shelley, will you read the second case, please?
Yes, sir. Case number V-22-057, variances to maximum dock size and maximum accessory dwelling unit size on prime agriculture A1 zoned property.
Mr. Shams, I believe this is yours.
Hi, good morning. Steve Shams with Planning and Development Services. This variance is for a property on about 205 acres in Dillon Springs. The applicant is seeking a variance to construct structures that are larger than allowed by the zoning ordinance. So there's 2 variances in total. Variance 1 is to increase the size of a dock and boathouse from 750 square feet to 3,677 square feet. And variance 2 is to increase maximum living area of an accessory dwelling unit from the maximum 1,200 square feet to 2,995 square feet. So variance 1 would allow the proposed dock size on Skull Lake. The applicant owns 14 lakefront lots and has a right to build 14 docks of 750 square feet. This total square footage is about 10,500 square feet. So the proposed dock, as well as an additional 750 square foot dock, totals 4,427 square feet. So in working with the applicant and county legal staff, they have proposed a dock rights release instrument, which would forfeit the rights to additional docks by the applicant on 12 of the 14 lots. This forfeiture of dock rights would save 6,073 square feet of docks on the lake. Rights to additional docks are forfeit until the large dock is destroyed, and then the instrument is null and void and the rights return to each lot. There are no active code violations on the property, and environmental permitting also recognizes the proposal would limit impacts to the lake and does not object to the variance if the dock rights release is recorded and approved by County Council. Variance 2 is for the accessory dwelling unit. The proposed ADU is accessory to the proposed single-family principal residence on the property, which is 9,610 square feet. The ADU meets all other dimensional requirements of the A1 zoning classification. The space for the proposed ADU will be used for recreation. And it is proportionate to the principal structure, which is consistent with the zoning code, as it is about 31% of the size of the principal structure. The zoning code requires less than 50%. It'll be located on a 200-acre homestead and not visible to surrounding residents. And in addition to this, the county is currently in the process of revising the ADU ordinance to allow ADUs greater than 1,200 square feet, but still less than 50% of the principal on properties larger than 1 acre. Overall, staff recommends denial on variance 1 and variance 2. Variance 1 fails to meet 2 of the 5 criteria for variances, as the special condition is a result of the applicant, and the literal interpretation of the zoning code does not prohibit them from constructing docks on all 14 lots. Variance 2 fails to meet one of the 5 criteria, as again, the special condition is also a result of the applicant's actions. Staff does recommend conditions for approval. All 4 are on the screen, and I'm available for comment or questions if you have any.
Any questions, Mr. Feller?
Thank you. It's a very quick question. You said 14 lots, but right now it's 4 parcels. They would have to subdivide those lots to get each one of those lots, or no?
So the parcels are tax IDs, the lots are of the unrecorded subdivision.
So each lot could be built on with a dock
Yes.
in its current configuration without any other work?
Yes, each of those lots are conforming to the zoning. They are held together under one tax parcel, but that's separate from the buildable nature of each individual lot.
That's all I have. Thank you.
Mr. Young?
Yeah, I got a legal question. This contract that they do, if for some reason those lots are broken up and sold off, are the people that buying the lots, this is recorded and they'll know on the deed that
Yes.
they cannot build a
Yes.
dock? So, okay, I wanted to make that clear because somebody couldn't come back then later on and say, I want to build a dock on that piece of property.
Unless the large dock is completely destroyed.
Thank you.
Anyone else? On page 3, first paragraph, it states that the second dock will be built on parcel 190190. Then in the release of dock document, section 1, page 11 of 20 states the dock can be built on any one of those 13 remaining lots. Should that not read parcel 19 as well? Should those two not agree?
I think maybe, Darren, if you could clarify that one. My understanding is that the applicant is proposing 2 docks, one of the larger ones, and then the other dock will be compliant with the current zoning regulations, and that compliant dock will only be constructed on the parcel that you just stated, which is 0190. And then the large dock can be constructed on any one of the other docks, which is, I think, consistent with the concept.
Right, but when I read it, it just appeared that what it says is that the second dock can be built on any one of the remaining 13. And so I'm just saying, if it's in the staff report saying 19, shouldn't it not say the same thing in the release of dock document? You find that on page 11, section 1, page 11.
Well, we can revise that to make sure that they're consistent, and make sure that second dock is consistent with because that's citing to the parcel number. That citation is to the unrecorded lot subdivisions. So we'll make sure that they're compliant on where that is actually constructed.
Okay, that's all I'm looking for, is some consistency with that.
That does bring just one follow-up question. So there will be the main dock, which will be associated with the parcel ID or the lot, and then one of those lots, how will that get recorded that one of those lots, if they haven't decided which lot will have the dock?
Well, the release is drafted such that it applies to, there's a legal description associated with the release, so anything in that legal description releases its rights to construct a dock and transfers it over to the parcel with the main dock.
So that's the only person that has control over which lot gets the dock built on it.
Right, and then I think the secondary dock we're talking about
Right,
is
the
the 750 square foot one, and that can be placed on any one of those identified lots on there, so long as one of those lots hasn't released its rights, and that's one of the things we'll make sure that there isn't, an unnecessary overlap. But that's kind of the concept is, the other parcels release their rights to construct a dock. In exchange, one parcel gets a very large dock and another parcel gets a small dock. We just need to make sure that None of those parcels that I referenced have released their rights.
Excellent. And you'll make sure all the legal's taken care of if we
Well,
vote
it
on
would, yeah.
We got to make sure that that it goes that way, I guess is what I'm saying.
Anyone else? Mr. Elkham, would you come forward, please, and give us your name and address and tell us what we need to know?
Yes, sir. It'd be my pleasure to do so. For the record, my name is Darren Elkine. My professional address is 142 East New York Avenue in DeLand. It is my pleasure to be here before you this morning. I'll clear this up and make it very simple and understandable in terms of this dock rights release, but let me first mention a couple of things and introduce the folks that are here with me. Although all of this property is owned, and Madam Clerk, if you can pull up that overhead, there's one in the staff report, but that one's in color. Thank you. With me this morning, although the property is in a limited liability company for estate planning purposes, the actual owners of the property are a young couple that are from the area, Jacob and Stacy DeGrom. Jake is here. And the builder, who will be building everything on the property, subcontracting some of it out, of course, is Mike Chinelli, who enjoys a very good reputation, at least in the west side of the county. The DeGroms have purchased, in totals right now, they'll buy more if they can, 566 acres, where they're both from DeLand. Jake works out of town now, but lives here. This is the home. This is where the children will be raised. This is where their home will be. And when they came in and said, well, we want to build this larger dock than what's allowed, it just immediately was apparent to me, well, you need to give up the rights to build the rest of them. So the plan with the dock rights release is they own, we're trying to pull up a map to show you, they own 14 lots on the lake, but they own a lot more property. There we go. This is not all of the property they own. The dark green lines are the subdivision lots. Those are exempt subdivisions. We've combined those for tax purposes in one tax parcel, but each one of those exempt subdivisions is legally vested with the right to build a 750 square foot dock. That's where that number comes from. They have absolutely no intention of selling any property off now. The DeGroms don't make their money through real estate development. And this is actually a working cattle ranch, and in a few years down the road, DeGroms will bring their own cattle out and be more actively involved in that process, and the children will learn it as well. The idea is that the dock, and there's a little, there'll be not a boathouse, but a building proximate to it, will be the large dock, which will have the boat at it. They would like the opportunity somewhere, probably to the east, where there's a really nice canopy of trees, to build a small dock, probably nothing for a boat, but something that you could walk out on, have a small terminal platform with a couple chairs, and sit at the lake. It's sort of I don't want to use the word romantic, because that sounds a little odd coming from me, but a nice place for sitting. So that's the idea of having two. This dock rights release is clear, and the intention of it is it will be recorded. It will be recorded in the public record, so anybody, if they ever chose to sell off one of these lots for whatever reason, whoever buys it is charged with it. It's an enforceable, just like any other deed restriction, it's enforceable, and they will not be able to build another dock. They control it, and that's just how it is, and that's tight, and you have a good lawyer who will make sure it's done correctly. I don't think you had any other questions with the dock. The one thing I wanted to be clear about, there was a requirement that environmental added. This is a technical point, but I'm a lawyer, so I get technical about things. To the extent that a wetland alteration permit and some sort of restoration plan is required, that's required whether you all grant a variance or not. If you have to do that for building a dock, or if there's some other issue that environmental is concerned about, I'm going to call and find out about that tomorrow. We'll get going on it right away, not a problem, get it done. It's not an issue. But I don't want it to be a condition of the variance. If we need to do it, we need to do it, and we'll go do it. I don't want it to be a condition of the variance. I just want that to be clear in the rendition that this is not a condition. You've put us on notice that it's required, not a problem to do it, We just want to be very clear and make sure the paperwork is done correctly. Any questions I can answer on the dock before I go to the ADU?
Does that create, with it being a condition on the variance, does that create some kind of complication for you guys?
Yes, if it's, because if it's required to get a wetland alteration permit
Well, I have it
for a building permit, if for a 750 square foot dock that doesn't need a variance, it's required. I don't want to think this is some additional condition. We're going to follow the code and get whatever permits are required. That's what we'll do. And if there's something out there that needs to be restored for some reason, we'll absolutely do that.
Mr. Sorry.
And we should be required to do that whether you grant a variance or not, in fairness.
Right.
It's more protection for the county in some respects.
Let me just ask Mr. to weigh in on that.
Well,
from the
it is required as a natural, as a, due course. What this does is essentially, if they don't do it, it's a violation of a condition of the variance and, renders the variance void if they fail to comply with condition 4. So what it does is it ties the variance and the validity of the variance to the wetland alteration permit and restoration plan, which is why your environmental division kind of requested it as a condition.
So as our legal representative, are you advising us to leave that in place?
Well, it depends if you want to put the variance as an additional leverage for obtaining that wetland permit, alteration permit and restoration. Because if they don't do it, they lose the variance and have to come back here.
Then may I? Mr. Chair, may I?
Please.
Just so we're clear.
Please.
I need to know, for clear on the record, and it needs to be clear here for you to vote, is it a wetland alteration permit and restoration plan solely with respect to the new work that is done with regard to this dock? Because if it's something else that I don't know about, I haven't been advised of, that's why I'm concerned.
That's why I want to make sure that everybody's clear and on the same page.
We got to do what we got to, listen,
Yeah.
let's be practical about it.
Yeah.
Unlike maybe on some other meetings, but I've got a client here and a builder who,
Sure.
be frank about it, have the resources, and they're going to live out there, and it's going to get done. I just want to be clear of what we're talking about. If it's the routine thing that is what's required for building a dock, then you catch that with the building permit, because you can't get the building permit without it. And if it's something else, and this is the hook to clean up something else that we've never been notified of, well, in fairness, I should know about that, and we'll take care of it either way, but I'm a little concerned about doing it in that fashion. So I just want to get it cleared up.
Absolutely. So can we get staff to weigh in on that and put Mr. Alkine's mind at ease that we're not talking about something else and there's nothing hidden under the sheets?
Sure. When we do variances, we submit the request to all of the different departments within the county. The environmental permitting team went out to this site to review the variance request. They found that there had been evidence of clearing. So they said that they would support this variance if that condition was added. They would not support the variance if the condition was not added. And that was from the environmental management director.
So environmental has been out there within the last year for unrelated to this variance. I read that for the first time when I read the staff report. It's tough when I don't know what it is that we're doing.
It doesn't appear to me now, I don't know, you're a lot smarter at that than I am, looking at the technical stuff, but that there's anything that's hidden that's outside of the norm that I'm seeing. And so if it's attached, I don't think you're going to get any surprises. But that's just from what I'm hearing, Mr. Young.
If environmental's been out and they're concerned about something, maybe at this point, if we're waiving that and they're saying that they think that they won't support it, maybe we should have environmental give us feedback as to what their problems are before we agree. That's just the way I'm feeling. I'm a little reluctant to waiver the whole thing.
And again, we'll take care of it either way. We just want to do it by the book.
Mr. Feller.
Just before, because I want to get this before we move on and before you go, I can be supportive of this because of the way it's been explained and understanding it, but I weigh heavily on environmental permitting. So if we were going to, I just want to make sure it's not a deal breaker for you, and I don't want you to be surprised if I vote one way. If environmental permitting says they want it in there, I tend to lean towards that.
And
And
Mr.
I
Fowler,
agree.
if you all need it in there,
Okay.
I think in the future, let's,
I just didn't want to shock you, but the other thing, and the only thing I'll say about it is, if it were just a standard one and you were getting it, then you would go and it would be outside of this committee, but we are asking to
I
make something
understand.
bigger, and for that, there's give and take, so, all right, perfect. I'm
Mr.
done with
Costa.
that.
Yeah, this is directed at staff, actually. If we were to recommend this for approval, and with 1, 2, and 3 only, when they go in to apply for a permit to build this dock, as a course of that permit, they have to submit a survey, they have to submit a wetland survey, I would imagine as well. And at that point in time, then it's determined whether or not they will need a wetland restoration permit. Is that correct?
That is correct, except in this case, there were some apparent violations found when they went out to the site.
I understand that, but those violations aren't in front of us right here. We have it,
Correct.
you didn't add them to the package, so there's no letter from EP that says, hey, we saw X, Y, and Z. And I think that's what Mr. Alkind is referring to, is that I don't know what you're offering me this token, and it may be for the fun ride, or it may be for the spooky ride.
Well, just to clarify, because this was a topic of conversation during this process, and environmental permitting's initial response was they would not support this variance at all. And then it was after further discussion with them that said they would support it as long as this condition is in the variance.
So then I bring
That's
my
how we
que-
got them to the yes.
So then I bring my question back to the applicant.
well,
Did that conversation occur, and
oh, I've never had a conversation about, that's an internal conversation, and if I go in, I've never received a notice of violation or anything. If we had, we would have taken care of it. I'm a little, I hate to address this. This is the sort of thing I take care of at a staff level. Let's do this, though, to make it easy and move on. We've got a lot of people here waiting. We'll be okay with that condition. The one thing I would ask you to do is that the wetland alteration permit is in accordance with county code. I want the record to be clear that this variance isn't requiring us to do something over and above what the code requires vis-a-vis environmental that I don't know about.
what language would you like to see there, please?
I'd like the language to say wetland, whatever the wetland alteration permit in accordance with county code.
Staff okay with that?
Yes, I mean, what it is it's just, it puts a time frame on it. So when you file for a building permit, there's going to be a wetland alteration permit and restoration plan for all the property according to code. So it just puts a time frame of when that has to occur.
We're okay.
We okay?
Yes, sir.
Okay. Does anyone else have any other questions pertaining to the issue that we're talking about right now? Mr. Elkin, would you continue, please, sir?
Yes, sir. Regarding the accessory dwelling unit, it is a pool house. Obviously, they're building a very big home on the site, and it's going to have a proportionately very large pool house. I think it might be bigger than my own house, but they call it a pool barn, and the style of it will actually be a barn. It's pretty cool, really, to look at. But somebody had to explain it to me because it didn't make sense at first, but when Trish or Ms. Smith took me through it, it in fact meets the technical definition of an accessory dwelling unit under your code. Thusly, we have to get a variance to the maximum size of an accessory dwelling unit. I understand that the county is considering some changes to the regulations, but they've been in planning for a long time on this project and excited to get going actually now. Not much more I have to say on that.
Okay, if you're finished, do we have any further questions for the applicant?
Not questions, but I was just going to say that, I've been a proponent of pushing the ADUs on these larger properties. I thought it was a mistake for us to pass an ADU regulation that dealing with 50 by 100 lots and then putting those regulations on.
Yeah.
So I can be very supportive of the ADU at this point. just
In
as-
fairness, they're not really using it, it's not really using
Right.
it as an ADU, but it is absolutely meets the code.
Yeah, and so, so permitting and all that stuff, I mean, it's gonna have all the things that require all that, it's not a farm building. Yeah, so,
All right, thank you, sir. We will give you an opportunity to come back if needed. Is there anyone here that would like to speak for or against this? All right, now we're going to close the floor to public participation and ask for council comments or a motion, please.
I'll make a motion that we approve case number V-22-057 with the 4 staff recommended conditions, altering condition number 4 to read as follows. A wetland alteration permit and restoration plan for the wetland buffers will be required in accordance with county code when the applicant applies for a building permit for the dock.
Second.
Yeah, that's good.
It's been
Good words.
moved and seconded by Ms. Shelley for approval of V-22-057.
And I have a comment before we vote. if
Sure,
that's
just a
all right.
minute. Utilizing the language that Mr. Costa gave us. Ms. Shelley.
I just wanted to make a note that I will be supporting this request, and two of the reasons relating to the previous request for an oversized dock is the fact that this family owns all of those other lots and also has come for a permit prior to the process, but they are also getting the dock rights release to prevent any other lots that are on the lakefront from building the docks. Thank you.
I don't think they own all of the
Well, the
lakefront.
ones that are,
Right.
yes,
The majority of
the
them.
majority.
Mr.
Thank you.
Feller.
yeah, I'd just like to, I mean, I looked over this one, and of course, your first thing when you get a packet is look at this. I think this is exactly what we're looking for in some of our preserved areas. So I could be supportive of this when I first read it, and I'm even more so now as we've gone through the kind of the nuts and bolts of it. And I think you're doing a great job out there. So that's all I have to say.
Yeah, one thing I'd like to comment on too, of course, numerous of us up here sell real estate. I've been selling for 20 years. And I've sold stuff from, of course, south of Orlando all the way to Tallahassee area. I've run across several instances just like this, where even if they sell off different parcels in here, they have one common dock area that everybody can use, and there's no docks all over the place. They have one beautiful dock where anybody there can utilize it. It's a great idea. It's got my vote.
I would just like to say, damn, he's building my dream house. But anyway, it's been moved for approval of V-22-057 with the staff's 4 recommended conditions. All in favor, say aye, please.
Aye.
Aye.
Any opposed? Passes unanimously. Thank you. Ms.
Something else I'll put out there, I've known Mike Schinelli for years. Anything he is behind is top notch, so it's gotta be good.
Ms. Shelley, may we have the next case, please?
Yes, sir. Case number Z-22-131, rezoning from the urban single-family residential R2 transitional agriculture A3 and business planned unit development BPUD zoning classifications to the urban single-family residential R4 zoning classification.
May we have the staff report?
Hi, good morning. Stephen Shams again with Planning and Development Services. This is a rezoning for a 28.49 acre site in West DeLand. It's currently zoned R2, A3, and BPUD. The applicant is requesting a rezoning to construct approximately 70 single-family homes on 7,500 square foot lots. The existing BPUD was intended to be a clay borrow pit, but development order expired, and it was never used for that purpose. The site is currently vacant and undeveloped. As you can see from the map on the screen, the site surrounding the subject parcel are predominantly residential, with some agricultural uses west of the property. The rezoning will not require a comprehensive plan amendment to change land use because the R4 being proposed is compatible with urban low intensity. Under this ULI land use, the property has a gross residential density of 113 units, so the proposed 70 units is well below the threshold. The project is outside of the floodplain, the natural resource management area, and environmental core overlay, but there are some wetlands on site. Environmental permitting has reviewed the project and does not object. This project is within the city of DeLand's utility service area, and the city indicated there is adequate water supply to service the property. Sewer service would require a lift station and a utility service agreement with the city. Overall, staff recommends forwarding to the county council with a recommendation of approval, as this meets all the rezoning criteria. And I'm available for comment or questions.
I have a comment.
Any questions for staff?
Yes, sir. Mr. Chair.
Mr. Costa.
Quick question for you. I just want to confirm something. You said if they built it with the current zoning in place, their maximum density is what?
With the current land use, the gross residential density is 113 units.
113 versus what, 75 they're asking for?
70, sir.
Okay, thank you.
You're welcome.
Any other questions for staff? The question that I have, has there been any traffic studies, anything of the roads? Is Beersford equipped for that kind of impact? Have we taken a look at that?
I believe Volusia County Traffic did perform a review, and they did not find any concerns or didn't have any objections to the project.
All right, thank you. Would the applicant, please, Mr. Woods, please come forward? Give your name and, well, you know the drill.
Good morning, and for the record, Michael Woods with Cobb Coal, 231 North Woodland Boulevard here in DeLand on behalf of the applicant. Good to see you all. It's been a little bit, and I'm happy to be before you with a project of this nature. It's kind of an interesting project in that we are coming in within the existing land use. We're not dealing with a land use and rezoning. We're working within the boundaries of what the land use already provides for. To the specific question on the traffic, I do believe it's attached in your staff report of the analysis by traffic mobility consultants. They did go through the review and process for it. Again, the total size, that 70 unit, because this is straight zoning. We are going to be going forward. This isn't a PUD. This isn't, this was first kind of discussed at the peak of those discussions with small lot subdivisions, and we thought we need to avoid that conversation altogether. And I'll talk a little bit about the nature of the surrounding area as well, which factored into some of our decisions for this process. But with the application or the approval of this application for the rezoning, you then move forward to straight subdivision platting to the code provisions that are required with external buffers, with the limitations of adjacent property, et cetera. The 2 points that I want you to kind of be aware of is, again, one, with the land use change, we were not asking for that. So we talked a little bit about the intensity or density of what could be done. But I think it's also important to talk about the design and the pattern around the property area too. Because you have a little bit, it's been an interesting evolution out in that neighborhood. You have some subdivisions that are immediately to our northeast corner. And I believe that's, sorry, let me grab this note right here. The Oak Hill, Spanish Lane, Raymond Avenue. It's an old plat from like 1956. But those are, 30 lots there, old subdivision, same size, about 75 feet. But the difference, obviously, with the old subdivisions and the new ones, no sidewalk, no internal stormwater, no buffering. In fact, I think even one of the roads in there is a dead end with no cul-de-sac, right? But that's how we developed back in the day. You also have some additional R4 zoning to our southeast as well. But what you also have out there are a number of larger lots. And there's no getting around that, and that you have a number. If you actually were on the, and I meant to print out a copy. You guys, do you have an aerial photo? Or can you, if I give you a projection, can you? Oh, yeah, okay. Just for the frame of reference there, this is the immediate vicinity of the property, and all that yellow is the unrecorded subdivisions that have been done out there, right? And basically with the unrecorded subdivision, it's a really great process, basically intended back in the day for a farmer Jim wanted to carve off property to his family without going through a full formal subdivision process. You could do so. There's very basic limitations into doing so. You're not allowed to have additional requirements for roads. You're not really required to obligate the county to provide any type of infrastructure. As long as your lots are large enough, and there's usually about 1.5 to 2 acres in size. And that size setting is really because the focus was on making sure you could dig 2 holes safely. One for your sewer, your septic, and one for your well. And so that's a design pattern that had been out there probably in the 70s and 80s to provide for a path of least resistance. Even some of those larger tracts there was already R4 in front of it, but you don't have to put in the infrastructure, you don't have to put in the stormwater. And again, that's the other critical path here. These larger lots, they weren't even necessarily required to have paved roads internally, because as long as the overall unrecorded subdivision touched a paved road at that time, you could do that. That's not a policy, and that's not a design process that the county encourages any longer. In part because when you have a large tract property like that without any internal stormwater, the stormwater capacity are the yards, right? And so you have these larger tracts of land, the buildings are built to the elevation, but where the water goes during a heavy rainstorm is in fact those yards. What we come forward with is a brand new subdivision standards. So you will come through, we will have, if you, I guess you can go back to our aerial photo that showed the BPUD. On our western property there in that left corner is that clay pit that never really got put to full use, but it's got a fairly deep topography contour drop down, so a really great location for our stormwater to be channeled towards. I think Darren's there, but yeah, in any event, the capacity there allows for us to be able to keep that. There is a little bit of a mention of wetlands, but that's within that area. Obviously, we're not going to be impacting those wetlands. For the most part, you can see the property is very high, very dry, limited impact on trees as well. So we're trying to come in and tread as gently as we can within the area, and coming in with a development project with 75-foot wide lots that's in keeping with the other platted subdivisions in the area. Happy to talk about any other kind of surrounding areas or whatnot. The thought process when it goes through the site plan is you'll have road connectivity from Beresford, which is on that north side, and a spine road to run down through the property and connect out to Ridgewood, which is on the western side. And then you would also have a single driveway that would connect over onto Fascio. Contrasting that with the older subdivisions where all those driveways back up onto Fascio directly. You basically have 3 points of access servicing the 70 units in the area. That's pretty much it from my end, unless you have any other specific questions. Happy to answer anything that you may.
Mr. Fellow.
I always have questions. You just said that where the borrow pit is.
Yeah.
Or was going to be. That is what you're going to use for stormwater retention, but that's also where the wetlands are. I don't think those two generally work together.
Again, it goes through the site plan process, but there is an ability to be able to accommodate that water without jeopardizing the wetlands in place there. This will have a very delicate touch with respect to that.
I have a few other things I want to make sure that they're not specifically, I don't want to make sure that grandiose things are attached to this, but I need to say a few things here. The traffic was not in our packet first off, and I mean, we usually get those stats, so if you have that, would love to see it, but I mean, I guess staff is saying that there were no concerns, but we don't have any of that. So I don't know anything about traffic, but I can say this. I mean, as a user, normal person, traffic is going to happen when you add these. But bigger than that right now is you said that the city, that it's indicated that it's going to require a lift station and a agreement
Yes.
for that. Again, I don't want to get into the grander things, but we have a water ordinance coming up here as well too, and there's some issues with that. So who's responsible for the lift station? The builder?
Yes, and in fact,
This be a private lift station then, or?
I do believe, I'm not sure at this point. I do know that in addition to the lift station servicing our project, which would be necessary, the city has already approached us that should this project be approved for additional space for them to have a pump station servicing their reclaim system that's out there for their flow as well. So we are in conversation with the city already for not only our infrastructure improvement, but also other systemic infrastructure improvement as well.
All right. And then the only final thing I want to say is I understand you're not coming for a comprehensive plan amendment or anything like that, but we are talking about changing the density by half. I mean, currently it's R2, the section that we're talking about going from R2 to R4 is 12,000 square foot max to 7,500 square foot lot. So even though it's not a comprehensive plan amendment, I mean, this is
The yield becomes the large, they are large lots in our mind, but they are smaller than the acreage that you would otherwise have. But I think they're also kind of in keeping with the areas that have already been improved when it comes to both lot size and actual yield as a percentage. We're coming in at about 2.8 units per acre.
And this is a personal side, I agree with that, but then the map starts looking like all of this, and that's where we come in a little bit sometimes where I worry that I understand that it's all surrounding. Eventually, it won't be surrounding, it'll be all of that, and I'm looking at it. So just understand I'm mulling it as I look at this.
Yeah, and that's, you know, I mean, I ride my bike down this area to go down to the Beresford Park down to the south. I'm familiar with the area there. I don't think it's an understatement to say that the policies of how that larger lot, I mean, again, if you could look at the zoning map, just one that shows the lots, yeah, so you can look kind of at Ridgewood Hammock there. You know, you got the larger lots, but those are all kind of flag lot cross-access easement stuff. If you could do that today, that probably could be repeated, but we've gotten away from that, from that design process and policy. Contrast that then with to the north, where I think it was Bob Fitzsimmons subdivision, where we've tried to do more traditional infrastructure in place.
We'll hear some more about this, but to the south of the BPUD, that A3 is currently one house per, what is that, is that 1 acre parcels? 1 acre parcels that all of a sudden become 7,500 square foot lots that now are abutting against other A2 and A3. So, I mean, I think that's the sprawl that we talk about.
Understood.
Okay, just, I'm bringing it up, just, you know me.
Absolutely, sir.
I'm honest.
Any other questions for the applicant? We'll give you a chance to come back, Mr. Woods.
Thank
and,
you.
We do have some participation requests here. Ms. Deborah Clark, would you come forward, please? Would you give your name and address for the record and tell us whatever you would like us to know?
Hi, my name is Deborah Clark. I live on 1110 South Beresford Road, just around the corner from where this parcel's wanting to be. I oppose this.
Can you speak up just a little bit more, please? I'll come up to the mic a little closer, maybe.
On the issue with the traffic has gotten terrible out there. I've been there since 89, and the traffic has gotten terrible out in that area. We've had so many other places being built out on Fascio and down through that area. There's been wrecks. People are speeding, and you know, more and more that we keep getting out there, it's making it worse out there for everybody, for animals, for people to walk. We have no sidewalks. You know, it's just not feasible to keep adding and adding out in that little small area. But if it would ever be, you know, we need more people to go out there and look at the traffic that it's already got. You can sit at my property and see people passing on double lines. It's really bad out there. and people are using it as bypasses to not go through town. So to add some more property out there, I just don't think that would be feasible at all. So I object to this.
Do we have any questions for? Thank you very much. Is it Jane Bowling?
Good morning. My name is Jane Bolding. I live at 1105 South Beersford Road, which is about 2.5 blocks from the proposed development. I guess I kind of don't understand in a way, because it was also listed as agricultural transitional, and I didn't hear any mention of that, but on the sign it says there were 3 zonings for this right now, and I don't know where agricultural transitional went. Do y'all have that?
Yes. A3.
Okay. Okay. Well, I live in A2, and the whole area out there, not just where all the A2 is, has the ambiance of farmland. It doesn't seem like a subdivision. And we've gotten a lot added in a lot of subdivisions. But if we want to keep any sense of agricultural areas out there, we need to stop. You know, I hear y'all talking about the water. You know, look what just happened, because there's hardscape everywhere instead of fields where water used to trickle down. I just ask you to say no more. Thank you.
Thank you. Candace Mills.
Good morning. My name is Candace Mills. I'm the owner of Beersford Farms, located at 1029 South Beersford Road. First of all, my husband and I are strongly opposed to this zoning change. Higher density near an urban core is acceptable, but this property is nowhere near an urban core. This would be like me owning a lot in downtown DeLand and requesting to rezone it to agriculture to put my cows on. My husband and I currently are zoned A2. The future land use for our property is RR, rural residential. Based on the county's comprehensive plan, it is not A2 to high density R4. That's quite a jump. This is not because R4 does not fit. It's because R4 does not fit with our rural landscape. It just doesn't mix. And just an added note, I only noticed the brand new public hearing sign 2 days ago. And there's no way it made it through Hurricane Tropical Storm Nicole. Brand new sign. So that being said, they're supposed to have it posted for at least 10 days. It really, just having seen it this week, really has not given the neighboring residents time to really prepare and evaluate the situation and be able to discuss it at this meeting. So therefore, at least any decision should be postponed to provide adequate time for the neighboring residents to plan for the meeting and the discussion. Currently, there's a newer subdivision adjacent to this property, which the attorney, Mr. Wood, discussed on the north side of West Beersford Avenue. That is single-family homes zoned R3. At best, this property should not be allowed to exceed the density of that development. Equally important is our concerns about the infrastructure around us. We have had these concerns for some time, only because we haven't seen any improvements since several new subdivisions have gone in within a 2-mile radius of us. And let's also not forget the subdivisions that have been approved but are not built yet, all in that 2-mile radius. Have you been off of Spring Garden lately? It's ridiculous. Our traffic has increased exponentially through our rural community. I have cows and horses. I have a horse that's a jumper. She tends to want to jump out there, and I have cars coming down my road. I'm basically almost at the corner of West Beersford and South Beersford. I have cars coming down 50, 55 miles an hour passing. I've almost been hit twice trying to pull my trailer into my pasture because people just fly through there. So we have dump trucks, we have semis, we have a lot of Volusia County vehicles, the big, the dump trucks, cutting through our neighborhoods to get to where they need to go because they don't want to deal with the intersection at 44 in Spring Garden. They don't want to deal with this, so they're cutting through our rural area. The county spent a fair amount of money recently just repaving South Beersford Road. And if any of you want to take a ride down South Beersford Road, you'll find out very quickly that the weight and the turning radius of these large vehicles have degraded the money you guys spent on that road. The railroad track is already messed up.
Thank you, Ms. Mills. I hate to cut you off, but we're at,
I just have one more very important thing.
okay, go right ahead.
Very
Go right
important
ahead.
thing. I have several, but this is extremely important. We need to talk about the impervious area. Currently, there's 28 plus acres that holds its own water. And there are wetlands on that property. I'm a biologist. I used to work for St. John's Water Management. Consequently, an R4 high-density change could max out the impervious area and intrude into that wetland area. The borrow pit is not part of the wetlands. They wouldn't have a borrow pit if it was a wetlands. It wouldn't be allowed.
Okay, thank you.
Can I have a question? though?
Now, we have a question for you.
I do have
Okay.
a question, sir.
Yes, sir. I'm a little bit further away on South Beersford, so I'm about 2 blocks away. You would go to the west and, yes. But we're at we're over 10 acres.
Yeah, you said something. I just wanted to clarify one thing. This is nothing to do with not speaking yet, but it's currently R2.
Yes, I realize that. I realize that. No problem.
Are there any other questions? Thank you so much. Very good.
Good morning. Can everybody hear me okay? Okay. Yes. My concern really...
Excuse me, can you give your
Yes.
name and address, please?
Oh, yes. My name is Barry Good. I live at 1665 Ridgewood Hammock in DeLand, Florida. I'm in the area that's labeled, or I live in the area that's labeled Ridgewood Hammock, which is directly behind this area. The field that this is on is slightly elevated. When I moved into the area, I understood that it was a little bit higher. My concern has to do with water retention, and if there are changes in that area, which include concrete, elevating the property, that could definitely endanger our area, because all of a sudden we have one more in, which I know it's only once every 500 years, but guess what? They're coming more often. I'm very concerned that we're going to have flooding back into our area. Understand that there's retention ponding, but it's something that concerns me. Additionally, I am concerned about the small lot size and the impact on all of our property values. Thank you.
Thank you, sir. Any questions for the speaker? Thank you, sir. Kathleen Miller.
My name's Kathleen Miller. I live at 1675 Beasley Drive in DeLand, which is not far from that. It's not on that map, but I can walk to it from my house. But I just want to challenge the gentleman that said that it wasn't going to impact traffic by much. I mean, I live in that area, and trust me, it's already horrendous trying to get out on 44 or any other major road. Everybody is taking the back roads that are, going through, going down Ridgewood and down Euclid and Beersford and so on, because they don't want to deal with all the excessive traffic that's already out there with the building that's already occurred. there's already been, as that one lady said, there's already been a development in that area of approximately 70 to 100 homes. And I'm just guessing, just because I see it, but I haven't gone in and counted the houses. But it's another development already there, which is at Beersford and Ridgewood, or Euclid and Ridgewood, you know, right there. To put another development of 70 homes in there, we're talking basically in each single household, there's mostly 2 houses, because most people have both spouses are working. If you have older children that are college or older teenagers, they generally got a car. You're looking at least an extra 140 vehicles that are just added to that road just for that one development that's already occurred, and you want to add another. You know, there's no extra traffic lights that helps us get out on the road. There's been accidents galore with people trying to get out. You know, people are taking the side streets through our area in order to avoid all this, and the traffic is already terrible to deal with. So I'm challenging whatever results this gentleman said he found, where the traffic was not going to be impacted, because it is. In our neighborhoods, we deal with it every single day, constantly. Any questions?
Is that it? Any questions? Thank you so much.
I agree with you. Thank you very much.
Let's see, Bob Pignataro.
Good morning. My name is Bob Pignataro. I live at 1610 Wandering Oak Lane. I just saw the signs a couple of days ago, so I'm not totally informed of what is actually happening, but looking at the overhead projection, I can see 70 units coming in, and as the previous people have said, the traffic, there's a lot of heavy-duty traffic coming down Fascio Road because they avoid all the traffic lights on the cut-through. So I am strongly opposed to it, and the rest of our neighbors have not been informed of it. They're working, so they haven't had a chance to get here, and maybe possibly you could have a meeting in the evening so that they could, you know, you could hear their concerns. That's it.
Any questions? Thank you, sir. Ms. Smith, could you please address the sign issue? There's been comments made that the sign has only appeared within the last 2 days.
Yes, sir. For all projects, we require the applicant to submit proof that they did post their properties. We do have evidence that it was posted by November 7th, and we do have photos of the signs that are posted.
Thank you. Mr. Woods, would you like to come back and provide us with any rebuttal?
So there are a couple themes that are coming up here for discussion, and I don't want there to be a sense that I'm dismissing any statements that are being made by the neighbors in any way, shape, or form. But I want to talk about what we feel from our observation versus what the burden is for us for our application versus the design and the engineering. With respect, I think first and foremost to traffic, I'm not sure, I don't know if all of you didn't receive the traffic analysis within your packet, but it has been submitted to the city and reviewed and deemed to be adequate and sufficient based upon your traffic impact studies and analysis. Yes, we all know we've had this discussion about the nature of traffic, and we are, you know, they did properly address that people from this subdivision and our neighbors here will travel probably half a mile, less than a mile, I think, up to 44. You've got access east to 15A, the truck route, and then loop back around there as well.
We've heard those kind of conversations about people speeding through, you know, ignoring the stoplights and whatnot through the cut through in the rural areas. We had that with a project on the outskirts of DeLand a couple of years ago. That is something above and beyond or outside the scope of what the traffic analysis is, other than to say, as we come forward and put in our project with yet another crosswalk, now we probably won't be able to get a four-way signalized stop sign at our driveway on Fatio, but there's a traffic calming presence when those subdivisions come in. At the very least, and this gets back again to the design pattern out there versus what we come forward with, I do believe the county's current standards for subdivisions require us to not only internally, but to our external, have sidewalks along the perimeter of our property as well. Those obviously aren't in place out there for the subdivisions that were done through the unrecorded subdivision, and as I referenced before, the older subdivisions from the 50s, 60s, and 70s. But what we come forward, we bring forward a safer design element out there. With respect again to the stormwater question, and that's kind of why I tried to allude or directly state to that in my initial presentation. You know, we are all acutely aware of the storm that we just went through, the two storms we just went through. We know the situations that we're dealing with. It's in the older design subdivisions before we required stormwater maintenance throughout the subdivisions where we have the issues and the problems versus what we have here now today. And with respect to that borough pit, it was an active pit. It's a man-made surface water, and that's what allows under the regulations for us to be able to utilize that, incorporate that into the design. And even if that doesn't have the capacity, we still have to provide additional stormwater on our site as is required, more so above and beyond anything else in the vicinity of the project there. I know that we are coming in, and you're coming in with 70-foot wide lots. I am surprised that we are at the process in the conversation that now even a 75-foot wide lot is a diminution of value of surrounding properties. These are the subdivisions that I had heard this planning board and this commission and council have been looking for the last 2 or 3 years of having a more traditional 75-foot wide lot subdivision, which is why we're coming forward with that now rather than doing some type of PUD with some type of density up here and large down here and moving around. We just wanted, what I heard was go back to your vanilla 75-foot wide lot subdivisions, and that's what we're doing. We're meeting the box requirement of everything that is asked of us by the county. And again, from a standpoint of where the property is located and the conditions on the site, we do have a treat area down in the south. That's that A3 property that we'll have to work very carefully with to minimize the take on the trees on the south side. But for the most part, you're having us come in and we're developing a cow pasture, right? We're not coming in to take down historic trees. We're not coming in to impact that environmental conditions. This is high and dry and where you probably want to direct your growth to be located from a planning perspective. Yeah, I think I touched upon the traffic, and again, you know, that ought to be in your staff report. I don't know if we want to comment any further on the traffic, but that has not been deemed to be an issue or a problem here. And there is a thought process to be aware of when you're talking about your roads and capacities. Typically, when we're talking about, are you bringing more traffic onto the road, there's the actual traffic that's generated, and we do the analysis for signalization, and that gets at your site plan level. But where we have the bigger conversation about the full network being able to absorb it is at the comp plan. Well, we're not changing the comp plan. So there's this presumption in there that that underlying land use could have that much traffic generated already. So I get your point. I think Mr. Feller made it that we are bringing in more units than cows don't drive. I get that. But we are bringing in vehicles, and the system will be able to accommodate that. If you have any other questions, I'm happy to answer them for you, but I think this is what we were, when other projects were coming in with smaller lots, this is what people were telling us, this is what we want to see out here, this is what we want to be developed, this is what we're supposed to be bringing you, and here we are with that. So,
Mr. Costa.
Mr. Woods, I have a couple questions and hopefully clarifications for the general public. You could have come in at 50 wide lots and potentially gotten to your 100 and 13 allowable?
Yes, and yeah, that, I mean, that's,
So in a nutshell, you've reduced almost 33% and are coming in at 75 wide lots, which are a pretty good size by comparison to what's currently being built throughout the county, which is the typical 40s and 50s that you're basically shaking your neighbor's hands from your bathrooms. So you've gone wider lots and lower density, number one.
and yes, and that was a concerted decision because of the feedback we've heard from the other projects of not trying to reach for too much.
Which in turn then less lots, less traffic, et cetera, et cetera, et cetera. Second question I have for you is regarding stormwater, because a lot of people are concerned about stormwater. And correct me if I'm wrong.
Okay.
You are required to maintain or retain any and all runoff from your particular property on your particular site.
That's correct.
Not necessarily the adjoining neighbor's runoffs, but your runoff, so that it doesn't impact any surrounding neighbors. Is that correct?
That is correct.
That is required by code?
Yes.
Okay. And that is obviously going to be part of the plan when you submit it?
Correct.
Okay. All right. Just wanted to clarify those items. Thank you.
I do have, Mr. Fellow.
I'll reserve some comments for the comment section of this, but I did want to just say one thing. I understand, and I bring this up just because I'm newer to the board, so I just want to make a clarification that I don't know what past boards have been looking for, but as a newer member to the board, I just want to be clear that I don't think 75 is a standard per se from my perspective as the board, but I understand what you're saying, that people are talking about it. I look at it a little bit higher level than that, but I just want to understand that I'm not part of a board that was pushing for 75 square
Understood.
foot. That's all I wanted to say to you. Thank you.
I would also kind of echo what he just said. I like to, I'm wondering when somebody's going to come in and say, we want to build acre lots and stuff, so. But, because traffic is atrocious.
Well, and
stuff, so.
if I could just kind of talk about that, because, we have those questions. We're like, well, where, there are properties that you can develop that, and they haven't, moved that forward. And part of that is the acre lots that we have now didn't have to go through any of the requirements that you would have to go through now. An acre lot comes in for a subdivision is still going to have to be providing the infrastructure and still have to do the stormwater. And you don't get to have the cheat of having your backyard be your stormwater pond. You don't, you're going to have to come in, you're still going to have to do your tree preservation area and things of that nature. And so, and that's not to say that any of those requirements are bad. I think they're good. But those acre lots that we kind of look towards, it was a different time. Similarly, even if you go into the older subdivisions, like from the 70s and 80s, that have like the 120-foot wide, up by like DeLand High School, that was developed back in the late 70s. Those subdivisions, and I think we've talked about this, we've talked about it at V-Card, when you platted those subdivisions before, you didn't have to have the infrastructure in place. It would be like 3 investors would come and buy the land, they'd plat it, individual builders would come along and stretch the infrastructure, the water and sewer, but you didn't have any centralized stormwater. And you basically didn't even have any kind of you basically had just plain asphalt that came through there. Now, that's a nice neighborhood. I like that. You can't build that anymore. So, and there's reasons for that. But when we look back to those subdivisions and say, why don't we do that anymore? It's because we're not allowed to. And that's a very frustrating thing, because now we come through with a project and say, we are building to what we have to do. You require these requirements of us. This is what we do. Well, it doesn't look like that. We can't get that for you. And that's a very frustrating, I live here. I live in DeLand. I've been here since I was 6 months old. I constantly have that question whenever someone says, I don't like this, I like it like that. So let's look at that subdivision and let me tell you the things that I'm not allowed to do anymore that those builders could. And I'll get off my soapbox, but I think we're on the same page of that. It's just, that's the reality. And so what we come forward is, okay, how do you build a 75-foot wide lot to give a little bit more elbow room and still make it cost effective and feasible?
Thank you. I recognize your hand. We traditionally, we don't do that but being that I did not state that we were going to close the public hearing, I want to give you an opportunity to come up and say whatever you want to say, but try to keep it within 30 seconds, and then we're going to move on.
You're awesome with your fight, and I appreciate that. But he talks about the older subdivisions and the stormwater and whatnot. We just went through catastrophic water. We still have areas that have standing water. Homes have been lost. We have a concrete jungle. He says that, you know, the older subdivisions didn't have to go through all the environmental, everything that the new subdivisions have to go through for infrastructure. There's a very new subdivision around here called Victoria Park. It has been underwater. It's flooded. The adjacent properties on Kipler are a lake, and that's because it was built where there was wetlands, and the runoff, they were told they had to maintain their water on their property, but it sure has gone everywhere. We had streets closed. We couldn't even get to our Publix. I mean, you guys got to think about that.
All right.
I'm very concerned about the water.
Thank you. Mr. Woods?
Well, you know, it's a fair point. You know, when you have a 500-year storm event followed up by another hurricane within close proximity, those systems may fail. But that's not what they're designed towards. And I think the overall point is, for the area in question, if we're worried about, you know, non-multiple hurricane kind of storms and the flooding conditions there, this project as proposed is better able to accommodate that than any of the surrounding properties that we have. And what I do here is we talk about that. We talk about there's existing flooding. What I don't hear is, and therefore we should go and retrofit some of these older subdivisions. We should therefore, do we take down one of the houses and turn it into a retention pond? Because you didn't have to do that back in 1975, but maybe we come back and do that. I know it's fresh in everybody's mind, but we still have to rely upon the engineering. There still has to be some solid metrics for basis for construction, and that's what we're working with. And that's as the project goes forward and gets to subdivision, platting, and then ultimately to individual building, it gets reviewed and approved. And that's the system that we have to work with. And I don't see any evidence with what's being proposed here that it's going to lead to the contribution or making the current situation any worse. I think we are, as Mr. Costa properly said, we are responsible entirely for our situation and our problem and for our impacts, and we can meet that, absolutely.
Thank you. Do you have any questions for Mr.
Yes, I have a
Ms.
question
Seller?
for Mr. Woods. The gentleman came up and spoke about your area being elevated concern versus the area, I don't know if it's a subdivision or where he lives. And one of the things I have heard, not here, but people just talking about the storm with those issues with that newer development is being built higher because of storm water and because of our storms. And again, like you're saying, can't retrofit, but then how that affects the areas that are around them that are getting their runoff because of just the fact that the homes are built higher and the land has been built up. Would you have any comments about that?
Let me ask my engineer if he might be able to.
Hi, I'm Sean Forty. I'm with KCG Engineering, professional address 1700 North Orange Avenue in Orlando. And I'm a civil engineer for the project. And we've done some analysis on this property already and the surrounding basins and those sort of things. And I can tell you the projects I've done in the land, you know, I take great care in because I do know the nature of this area. I've been here for a while as well. And I saw what happened during even Charlie. There was, you know, back in 2005 and 2004, there was flooding back then. So these projects are designed to hold, you know, at least a 100-year event. And a lot of times I design them to do the back-to-back 100-year events just in case there is two events. And that's part of the district requirement as well if you can't fully recover upon. But in this case, we do have a pretty substantial existing borrow pit on site that we had environmentalists review, and it's not actually a wetland, it's considered a borrow pit. And we can hold at least a 500 event in this one event, a 500 event in this depression. From my experiences in the land as well, we actually have a subdivision that is all of our subdivisions are performing flawlessly through these storms. And we have a subdivision adjacent to us, an older lot subdivision that did build a pond. They're having to pump to our pond right now. So it is kind of a funny situation that you have these 1 acre lots for their pond, and they're pumping to our dense subdivision because we over-design our ponds for the most part. So my goal is to sleep at night, and I don't want to flood anybody.
I guess then my question to you, will that area that was being talked about, will they be able to pump to yours as well? Or how is that accomplished?
We have to accommodate stormwater from ourselves and any existing basins that come towards us. I cannot back water up onto another basin. So when we drew the basin map for this, we use LiDAR and a combination of other data to figure out how much land from surrounding this project is coming to us, and our pond will take that basin in its current condition, whether it's a house, a subdivision, whatever that might be. If it's offsite and it's coming to us, our pond will be sized to hold that for the same events that we're designing.
Thank you.
So.
Any other questions? Thank you, sir.
Thank you very much. I appreciate your
I'm
time.
going to close the public hearing now and open up for commission comments or a motion.
I do have comments if we can before motion.
Mr. Feller.
I probably have a lot of comments, so I'm sorry, but this is a big thing. So there's been a lot of talk about certain things, but I also look at, something was said of the burden of and I know, Mr. Woods, you've got a tough job here, and the burden's on the applicant, but there's been words like adequate and sufficient and all of these things, and I'm not talking about any one particular storm, I'm talking about just living in the area and driving around. Victoria Park, I live out by Venetian Bay. They were underwater, trampling over, everywhere. The idea, I think, is right. I think the county puts forward standards. I think our county staff is amazing. I don't always think those standards are right for what we're building to. I don't think we find that out until much later down the road. And then much later down the road is somebody who's been on Taylor Road for 30 years and is all of a sudden, for the first time ever, buried underwater, but it's the storm's fault. I've heard 6 people come up and speak against the project, and four of those 6 people mentioned traffic. This is another take where I'm sure that whatever standards have to be met or traffic standards need to be met by a subdivision, Mr. Woods, come forward. But I just don't think they take into account the real world of what's happening in our neighborhoods. And I live off of one of those roads. So I understand this isn't a comprehensive plan amendment. I look at it and I say property rights. Everybody has the right to do what they want to do with their property. I look at it as an R4 and I say to myself, well, that's probably still a lot of building, but he has a right to do it if he's on R4. What we're now doing, or tasked to do, is rezone it to allow that to be double. And I am, for a number of reasons, am having a hard time getting around doing anything with this because there are a few things, and again, I don't want to put the water quality issues aside, but as we look at sanitary sewer and water as ordinances, I'm not sure that we're there to handle what will happen. I will respectfully disagree with you. I don't think the old design of the neighborhoods is a problem. I do believe it is for some safety concerns and all that, but whether it was right or wrong, I think what we're seeing, or what I'm seeing, is these new developments are having an impact. We can argue what that impact is, but these new developments are definitely having an impact. And I worry about exacerbating that impact by making this variance change. So I probably have a lot more to say, but I'm going to end it there.
Anyone else like to make a comment? All right,
I'll say something. I'd just like to reference back to a case we heard last month. And Mr. Feller brought up the concerns of the neighbors and the people who have to live out there, and I'll rest it at that.
I know, Stoney, I do understand what you're saying. I do understand. I think that one house on 2 acres next to one house on 10 acres is different than A3 is one house per, I'm sorry, hold on. And I know that's only part of it, but that's one house per 1 acre, one house per 5 acres, and then going to potentially 3 houses per acre. So, I mean, if you took the combined, you know, I absolutely get it. I'm not saying that I'm against. I actually will go on record of saying I'm not against this development. I'm probably more against the density of this development based on current things.
Okay, we're gonna dial it in now.
I'd
We're
like-
ready for a motion?
I'd like to make a motion, Mr. Chair. On case Z-22-131, I'd like to make a motion that we forward the rezoning application on case number 0-22131 to County Council for final action with a recommendation of approval.
Do we have a second?
I'll second.
It's been moved by Mr. Costa, second by Ms. Shelley, that we forward Z-22-131, that we forward the rezoning application to County Council for final action with a recommendation of approval. All in favor, say aye.
Aye.
All opposed, say no.
No.
No. So let's have a roll call, please. Mr. Feller.
Is she going to call it? Do I have to wait for you? I'm sorry.
Member Feller?
No.
Member Young?
Yes.
Member Shelley?
Yes.
Member Bender?
No.
Member Costa?
Yes.
Member Sixma?
It sounds as if we have a 3-3 tie.
So what that means is that the question proposed fails. Mr. Chair, you can entertain any other motions, whether that would be a recommendation for denial, or I suppose if Mr. Woods wants to wait, a continuance, so that you have a full contingent of the board, or you can take no further motions and it goes up as a technical denial to county council. You can't make any findings, just you didn't have the adequate majority to render a final determination.
Can I ask a question of legal? So if the motion were made in the converse and it went 3-3, the same thing would happen?
Yes.
Correct?
Yes.
So I guess the question then is, I'm sorry, may I, Chair, for a second?
Please.
The question then is, if we go and it's a split decision to council, it will become a council decision. Or the other option would be to continue it until we had a majority, which at some point we could then have a majority decision go, but that would not be until January of next year.
Is
So I
that
don't know.
continuance, is that continuance requested by us or by the applicant?
Yeah.
It should be, in conjunction with the applicant, because it is the
Yes, it's
applicant's
the applicant's
application.
choice.
Right, no,
I
that's
would
what I'm saying.
recommend that we just let it go to the commission. That would be my recommendation.
I'm going to, at this point, give Mr. Woods an opportunity to weigh in on this decision before it's made.
Well, I appreciate it, and I appreciate all of your votes on here. I think we can go ahead with the technical 3-3 tie, how that is presented to the council and work through those issues with them at this time. I don't think waiting till January is gonna shift too much, so.
Okay.
Thank you
great.
very much.
Thank you. Okay, so it's settled. It's gonna go to the county council.
With no further motions, this will go to county council with a tie, without a recommendation for approval by this commission. Thank you.
Right. Thank you. Ms. Shelley, may we have the next case, please?
And that would be, making sure I have everything in order still. I mean, 31?
Should be
Z dash-
140.
Oh, I have it out of order. Thank you. Z-22-140, rezoning from the prime agricultural A1 zoning classification and the transitional agricultural A3 zoning classification to the transitional agricultural A3 zoning classification.
Thank you. May we have the staff report, please? Mr. Shams.
Hi, good morning. Steve Shams with Planning and Development Services. The application is for rezoning for a 49.33 acre site near Deltona. The properties are currently A1 and A3, and they're going for a full A3 rezoning. The applicant is requesting the rezoning to construct 23 single-family homes on 1 acre lots. The rezoning would make zoning consistent across the properties. There's currently about 18 acres are already A3. The A1 area is being rezoned to A3 because of the 10-acre lot area requirement would restrict density to 3 dwelling units on 31.41 acres of the property. The site is currently vacant and undeveloped. The surrounding areas to the east are City of Deltona residential. Properties to the west and north are rural properties with single-family homes, and the property to the south is a large vacant agriculture parcel. The rezoning will not require a comprehensive plan amendment for land use because A3 is compatible with the rural future land use. Under the rural land use, property has a gross density of 49 units, and they're proposing 23 units, which is well below the threshold. The project is within the enterprise local plan area and consistent with policies found in that local plan. The applicant is also coordinating with Volusia County Development Engineering to expand the Volusia County Trail through the property. You can see it on the map on the south side. It's that diagonal corridor going from west to east. The project is outside of the floodplain, the natural resource management area, and the environmental core overlay, but there are some wetlands on site. Environmental permitting has reviewed and does not object. The property is within the City of Deltona's utility service area and has adequate water, sewer, and reclaimed water supplies proximal to the properties. Overall, staff recommends forwarding to the County Council with recommendation of approval as it meets all rezoning criteria, and I'm available for comment or questions.
Any questions for staff?
One quick question.
Mr.
On
Felt.
the map that was just up, if we could, really quickly, are all the parcels, are all the parcels A1, or, so we've got one designated as A3 and one A1. Are all the ones that are not designated, are they the ones that are A1 that are going to, that we're rezoning?
So the way the map is labeled, there is a blue hatched line
Yes.
going across. Everything above that is A3. Everything above is A3. Everything below is A1.
Gotcha, so I see how it is now. So
Yes.
the upper side, the north side is A3, the lower side is A1.
Correct.
Okay, thank you so much for clarifying.
Any other questions for staff? Would the applicant please come forward?
Good morning, Joey Posey, 420 South Nova, attorney for the applicant, and I just wanted to add a few points that I had a little PowerPoint here that just to walk through and show you guys a little extra if that wasn't in the staff report, just to get a sense of, this has been a long time in the making. We've been working with the enterprise folks for a very long time out here, and once upon a time there was many different renditions of this plan, and I think we've gotten to a point where that 1 acre is that rural feel that everybody wants out there, and we have a cooperative owner who understands that that's consistent with what everybody wants. And just to point out, oh, not this. How do I go forward? Oh, got it. Okay. So yeah, we're just really redistributing the entitlements on the property. It's consistent with enterprise local plan. We're not requesting a future land use change. And the next slide is the interesting one. I just wanted to point out that this actually was once upon a time platted as 50-foot lots, and back in 1925. And coincidentally, there are a number of lots here that have vested rights. And again, that's just to give context for, what may have been 100 years ago that coming into today, and our goal is not to do that. Our goal is to make this consistent 1 acre lots, and really just try to give it that rural feel. We want to comply with all of the enterprise local plan requirements for the building specifications and try to give that old Florida feel for a lot of the houses. So other than that, it's pretty straightforward, and I'm available for questions, or if there's anything that you guys need from us that maybe we can help with. We're always available and trying to work with neighbors. So,
do we have any questions, Mr. Fellow?
How is the water going to be handled for this? Just since that's a big concern.
Sure. Well, my non-engineer mind is I know we were proposing the stormwater going towards the back where we didn't want to develop where you see the rail trail system. That the stormwater system would be kept on the back end.
But outside of that, I do have the engineer who, if he wanted to add any
Well,
details.
will this be serviced by public utilities, or will this be well and septic, or how are we looking, what are we looking at?
We're working with Deltona on that.
You're working with Deltona?
Yeah, and it's partly because of the interlocal agreements between the two jurisdictions. And our goal is if we can get sewer out there, that would be great. There is a connection through the subdivision on the east. And if we can, part of this is a feasibility question, because when you're working with such a low number of lots, you got to figure out how to get it there. But there is one right on the line there that if we can make it work, that's what we want to do.
I say that only because obviously there's a lot of water stuff on the agenda for today. Those interlocal agreements are a little bit of a tough spot, but I understand where you're going with it, I think. But at this point, it's meant to be Deltona, City of Deltona, to handle the utilities on it. Alrighty, and hopefully Volusia County can hammer on
And
Deltona.
we're getting a sense everybody's working together. That helps.
All right. Questions I have right now.
Any other questions for the applicant? Thank you for giving me an opportunity to come back and provide rebuttal. Mr. Smith, Stephen Smith.
Good morning, commission members and staff. Thank you for your time. My name is Stephen Smith. I live at 129 Sherrill Drive. I'm approximately less than 100 yards from this property as the crow flies. My concern is, well, first of all, I'm glad to hear that you're working with the City of Deltona, because that was one of my first concerns. We're talking about 30 plus acres being rezoned. So at A1, that's 3 houses, 3 septic tanks, 3 wells. At A3, that's 30-some houses, potentially, with septic tanks, septic fields, and wells. Granted, it's not a lot of houses, but there's a lot of concerns that my neighbors and I have regarding County Road 4162, which is Doyle Road. Our map went away. It runs on the upper side of the map there. As you are probably aware, the City of Deltona has put in 3 new developments within 1 mile of this property, totaling on the order of 400 new homes. Doyle Road is overwhelmed with that traffic. It is unsafe to cross Doyle Road at crosswalks that have lit signs of pedestrian crossings. And granted, you're only adding 20 more homes, 40 more cars, but Doyle Road is going to need some enhancements. So I don't know if the County Road Works Division has investigated what's going to be required there. I know for a fact within 1/8 of a mile of this property, there is still a 1/4 mile long stretch of Doyle Road that does not have improved shoulders. I don't know why the county didn't do that when they improved the shoulders along the rest of it, but there's definitely work to be done there. Further, the street we live on, Sherrill Drive, is used as a shortcut between Fort Smith Boulevard on the north and Doyle Road on the south, and that traffic just keeps getting worse and worse. It is not patrolled by the Sheriff's Department. I've seen 1 speed trap on our road since 1998 when we moved there, and I'm just concerned this is just, although just a drop in the bucket, it's eventually the bucket's going to overflow. So those are my concerns.
May I say something? Yeah. Phil. Sir, really quickly before you leave. I live out on 415, so I'm very familiar with where you are here. And the one thing that I would like to say is I look at a development like this and I shun the developments in Deltona. It was pretty shocking to me when we had a hearing about something, City of Deltona residents were out at their commission meeting, hearing, but then nobody shows up to a county council meeting to talk about something that was happening there. So I applaud you for coming out at least to talk about this, but I will say, I live on one of these ranchettes, if you will, 2 acres and such like that. And I don't think that those are the problems. And while you're saying they're a drop in the bucket, I know they're a smaller issue, but these other big developments, I think we still have to find a balance between it. And I appreciate you coming out and talking about it. But
One last thing, if I may. That particular property serves as a wildlife corridor. We have deer on our property, which is on the north side of Doyle Road, and that wildlife corridor goes all the way down to the Lake Monroe Conservation Area. that's all gonna be wiped out.
Well, with respect to say it's going to be wiped out, I mean, I still have I catch it on my cameras all the time, wildlife going through. I understand what you're saying, but again, I look at this, and the other thing I wanted to clarify was that half of it's A3, half of it's A1. So you're probably in the realm of not nitpicking the number of houses, but
Well,
yeah.
per the posting in front of the property, it's 31 acres plus of A1 being rezoned. So that's where I came up with the numbers, 31 new septic fields and 31 new private wells.
Okay, gotcha.
And further, I don't see.
Of the 50 acres, I see what you're saying. I see.
Yeah,
I
the
get
total
where you're
is
going to.
50
Yeah, I see where
acres,
you're
right.
coming from.
Lastly, since I still got 57 seconds, thank you for pausing that. I don't understand how the property south of the rail trail, which exists, I misunderstood earlier, it sounded like it was being put in. That is an existing bike trail where the old rail goes. I don't understand where the roads are leading to those houses. Are those going to cut across the trail?
We're not proposing anything behind the trail.
But you're rezoning that.
Well, because by nature.
Let's, hold on a second. Let's not have that secondary
Okay.
conversation.
All right. Thanks again for your time.
Thank you.
Thank you. Okay, let's see. I have a Teresa, is it Luis? Luis?
Which one? Both?
Trombo.
I'm Teresa Louise at 2410 Lush Court, unofficially Deltona, unincorporated Volusia County. First, I want to say thank you for Mr. Goldschmidt, who you're representing, to be working with us, and I believe I'm the person that he is discussing. I have about 60 homeowners and property owners that I am communicating on a regular basis about this property. I live due west on Lush Court, one property over from the one that you see. So we are zoned A1, which is 1 for 10 acres. We are all 10-acre lots over there. Everything to the east or to the west of us is that or bigger. So the only consideration that you have there is City of Deltona, and of course it's a subdivision. My main concern, and County Roads is calling me right now. I have two main concerns. One is the flow through of the water. We do have an issue with water, and this is before what happened in the last month. I have had standing water on my property coming off of the west, or the east of me, for the last year and a half. So to say it's not in an area that's a concern, it is, because I have had standing water at my property. I can show it, I have pictures, I can prove it. So the flow through of water for me is a major concern. If you then look at the flow of water being caused by what's going on to the east of us, in between you and myself, the Osteen Elementary School is basically underwater at the road. The students are having to walk in the road in order to get to school. This will be a walking community, so we need to look at what's going to happen for these kids walking to school. The other situation we have is the level, as Mr. Steve discussed, of Doyle Road. Currently, the last report I have is Doyle Road is considered a D-level road in between Saxon and Cortland. That is based on Volusia County Road and Bridge. I asked them for an update. That was them probably calling to give me an update. That report was as of early this year, being a D level. That means how many vehicles are on it, the type of congestion we have, the type of road it is, mentioning there's no shoulders. There are currently no shoulders out there. And that is because there's homes that have to be eminent domain. I would like to bring up the external buffers. I want to make sure in the plan there will be external buffers for all of us that have larger properties. And then also the school congestion. We have currently approximately 4,800 new people coming in to the 20 homes that are already approved. I'm not against this subdivision as it is currently being presented, but I want to make sure that all of our comments are taken into consideration going forward.
Thank you. Any questions?
You've been working with Ms.
Yes.
Posey and that. How is your relate?
Not
Oh, not with
no.
the firm, not with the firm, but with the
Mr.
developer.
Goldschmidt.
Yeah. Exactly.
Mr.
How
Wiltshire.
has your interactions been? Do you feel like they've been representing your concerns? Do you feel like you've been kicked to the curb? Tell me just if you could really quickly.
He's listening. He went from an original proposal that I believe was either February or March of 2021 of approximately 165 homes down to 23.
So
I'm not against the current proposal. My worry is this gets approved and then they're going to come back and say, okay, now we have 51 acres in this grouping. We want 51 homes. So I'm not against 23. My concern is he keeps lifting it up higher.
But to your extent of working with them,
He's working with us.
Okay, thank you.
So the other is the city of Deltona. My understanding is that this property cannot be annexed because it would make an island of the properties that he doesn't own. So that is our only saving grace because of Volusia County. So I hope you guys stick with what's going on.
All right. Any other questions? Thank you. Mr. Coulter, would you come back now and provide any rebuttal that you'd like?
And the neighbors' comments are well taken, and, again, you know how we operate, that I will even put it on the record too. I'm happy to meet with you guys and walk through everything. We want to keep you involved in the process and make sure this is something that is everybody can be proud of. So we're on the same page. So the thing I do want to clarify, we do not have any development proposed behind the rail trail. That would just be difficult in itself. So it's just much more conducive to the layout of the land to just leave it in its natural state, or really just, we were thinking about using it for drainage too. And that's another issue that I heard pointed out, that, we're very sensitive to that. And we want to be as transparent as possible when it comes to that. So as part of our site plan, we want to keep the neighbors involved, show them how this is a net positive for everybody. And the other thing, just to remind that, although we're talking about the zoning entitlements in terms of just A1 to A3, what we really have to keep in mind too is the vesting that I was talking about earlier. That I didn't throw the number out there, but by my calculations, I could put 50 wide lots on the property, and just because of the nature of the platting that occurred 100 years ago. Have no plans to do that. I just want to be clear about that. But that's not to say somebody after me may. But you sometimes the known quantity is something that you can work with rather than the unknown. So I just want to make sure that we understand that part of this, because our goal is not to make this difficult for anybody. We want to make sure that we have utilities in the same way, that as long as it's feasible, we're happy to do it. So, you have my assurances on that part. So, hopefully we can work together and keep moving, and, maybe even come up with a little model of how something should be done in the enterprise area. So, other than that, I'm available for questions.
Do we have any questions? All right, thank you. We are going to close the public hearing. Yeah, we've already closed the floor to public participation. So, Mr. Sawyer, do you have a?
It's up to the chair to open it back up, but if you do, and they say something that requires a rebuttal, Mr. Posey should be given the opportunity to rebut any comments. But it's up to the pleasure of the chair of whether or not they want to reopen it. Usually you don't, but
okay.
you can.
Well, we're going to stay with that the floor is now closed for public participation, and we are going to see if we have commission comments or a motion.
I'll be happy to make a motion, Mr. Chair. Case number Z-22-140, that we've motioned to forward the rezoning application on case number Z-22-140 to the County Council for final action with a recommendation of approval.
Second.
Okay, it's been moved that by Mr. Costa, second by Ms. Shelley, that Z-22-140 be forwarded to the County Council for final action with a recommendation of approval.
Quick discussion really quickly. Just, I want to just mention one thing. Since developments are a thing that's going on here, there's going to be further talk about water quality and all these things that I'm sure most of the room will clear out by the time that happens. But I think from my standpoint, when you hear me vote, it's because I look at each one of these as an individual case and what they have to offer and how they're bringing something to their land with their rights to use their land and how that works. So when I vote, I want people to understand this is not just you're for development or you're against a development, development in general. So thank you for letting me comment that.
I just have a comment. Now, I believe that's how we all look at the cases. Thank you.
Sure, I'm sure. I just, again, I think a lot of people get caught up in their individual case and then they walk out the room and they don't hear things, but then all of a sudden developments in Deltona happen.
Okay,
I want to make a comment real quick
Mr.
too,
Sick.
and I agree with Mr. Feller on that. Every case is individual, the way we vote. But I was happy to see this is 1 acre, I think. It really goes nice with the area out there, and it could be a whole lot worse, so.
And it's better
I
than a
think 1
bar.
acre fits right in with the surrounding area, so.
Okay, we're going to take a vote. We have, we're forwarding the rezone, the motion is to forward the rezoning application case Z 22140 to the county council for final action with the recommendation of approval. All in favor, signify by saying aye.
Aye.
Aye. Any opposed? It's unanimous in favor of. Ms. Shirley, may we have the next case, please?
Yes, sir. Case number PUD 23-002, a rezoning from urban single-family residential R4 to residential planned unit development.
May we have the staff report, please?
Hi, good morning. Steve Shams again with Planning and Development Services. I just want to make a few notes before I start. So a revised packet was provided after publishing. I think everyone received that. And we processed the application for the proposed number of units.
Excuse me, Mr. Shams. Can we get you all to take your conversations outside, please? Excuse me, in the back of the room. Would you all take your conversations out of the chambers? Thank you. Thank you, Mr. Shams. Go ahead, please.
Okay, as I was saying, we processed and reviewed the application for the proposed number of units at the time, which was 195. Yesterday, the applicant notified us they were reducing the number of units to 135, so that's not reflected, but so the PUD agreement, the changes that were made in the revised packet were to add an additional use. So they added single-family cottage homes. They were added to supplement the multifamily and two-family housing units that were originally in the application. So overall, the site is a rezoning from the R4 zoning classification to RPUD on a 40.91 acre site on State Road 472. This site is located approximately a quarter mile west of the Southwest Activity Center near the I-4 interchange. It's subject to thoroughfare overlay standards along State Road 472. The site will have 2 access points, one on State Road 472 and on East Minnesota Avenue. The applicant is requesting the PUD designation to construct 195 dwelling units. This is what was in the application, with a mix of single-family, two-family, and multifamily units. The housing mix was not allowable under the R4, which is the reason for this rezoning. In addition to the mix of housing units, there will also be a 2,900 square foot clubhouse, a pool, and an 1,800 square foot exercise room. The site is currently vacant and undeveloped with 16.61 acres of wetlands, and is expected that about 0.27 acres of direct impacts to the wetlands will occur. The PUD development agreement was reviewed by the county and met the PUD requirements. This includes 20% minimum common open space, consistent dimensional requirements on all the housing units, landscape buffers, and wetland buffers as well. The project is consistent with the comprehensive plan as it is designated urban medium intensity. UMI allows 4 to 8 dwelling units per acre. The original application's gross density, the property's gross density under this UMI designation is 196 dwelling units, and the original application proposed 195, which is consistent. Environmental permitting's review indicates the site must comply with tree preservation and wetland preservation, and encroachment in the wetlands will require wetland alteration permits and mitigation plans. The proposed PUD will result in about 1,325 daily trips and 104 PM peak hour trips. This is a reduction in the standard R4 zoning, which would have resulted in about 1,680 daily trips and 167 PM peak hour trips. Volusia County's traffic engineering has reviewed this project and did not object. The property is within the city of Orange City's utility service area and has adequate potable water and sewer service capacity. The site also meets school concurrency, as the Volusia County School Board has reviewed and found capacity for any potential students. Overall, staff recommends forwarding to the County Council for approval, as all criteria are satisfied, with the one condition that approval is subject to the staff recommended order and resolution. And I'm available for comments and questions.
Mr. Fellow.
One question, it's 135 or 195? Because you'd said in the staff report it was 195 again. Is it 135 units?
So we were notified yesterday that density had changed, but we reviewed the application to 195 and it was consistent with everything that we require.
Okay.
Any other questions for staff? I have, on page 3, it states that the minimum living area per dwelling unit is as follows: 450 square feet for a one-bedroom, 440 square feet for a two-bedroom. Is that correct? Should that two-bedroom be larger than the one-bedroom?
I believe that's meant to be 540 square feet.
Okay, make that correction. And on page 30, there was, let's see. It says, in that first paragraph, it says, with this application, the applicant's zoning application shows that part of the roadway system do not have capacity to accommodate new trips. If the amendment were to proceed, a mitigation agreement would be required during the rezoning process. Now, what are we talking about there with the mitigation, and how does that work?
Mr. Chair, that's usually the proportionate share agreement. So there's a calculation based on the amount it would take to bring that deficient segment up to the level of service, and then the applicant's fair share of that amount is required to be paid. I think it's usually prior to construction plan approval. And what it essentially is I hate to say this, it's kind of like a prepayment of the impact fees. And so that impact fee payment, which is usually due at the time of building permit, is paid in advance based on the proportionate amount that would go into the system to fix that deficiency. Now, it's essentially money. So how it works is the county has to collect, fair shares amounts from multiple properties in order to reach the level to fix whatever is deficient. So that happens later in the process. If you pay attention to the county council, you'll probably see it on the consent agenda as a proportionate fair share payment and agreement.
All right, thank you. Any other questions for staff? Would the applicant please come forward?
Good morning. For the record, Nika Hosseini with the law firm of Cobb Cole, 231 North Woodland Boulevard in DeLand. I think we have a presentation for you guys, if we can get that up. Awesome. Pull this from here, maybe. I'm not good at this. Okay, awesome. Okay, cool. Yeah, great. Good morning, everyone. So I think your staff did a fantastic job kind of reviewing everything and why we're here. Mr. Bender, I think your confusion with, previous comments is that this is a somewhat special case in that an application was taken over. So there was a previous application submitted for, an apartment complex, different things going on, as well as a comp plan amendment as well. And then the application was taken over by another entity, and a new project was developed based off of that. So some of the comments you see towards the back of the packet from the previous application, and now we're here and we amended that application to take away that comp plan change. So there is no comp plan change, there is no land use change, there's only a change from R4 to PUD. And to get started, the reason why we are making that change, it's not to increase density. We're actually lowering the potential density. It's not to, change traffic patterns or access points or anything of that nature. It's purely because the type of housing product we're bringing is a little unique and different. So it's cottage style. They're really cute little housing style types. And your code hasn't really seen that type of housing. Similar in Daytona, they had to also switch to a PUD to be able to build these cottage style housing units. And so because in R4 it only permits your basic single family house, we weren't able to meet that kind of criteria and slip in under R4. We're still meeting your future land use, which is UMI, which you have to have a minimum of 4 dwelling units per acre, up to 8. We're around 5.5 net and less than 4, 3.2 gross here. And so our goal here is, because we do have wetlands on the site and we do want to protect that and minimize and mitigate if we need to, is we want to cluster. So instead of having single family residences kind of spread out all over the site, we wanted to cluster our development into certain corners that we have uplands on and preserve the rest as both wetland and open space. If you notice, a PUD requires 20% common open space, R4 zoning does not. So we could theoretically come in, double our development area under R4 and not have any common open space. So no, passive recreation, no nature trails, no clubhouse, nothing of that nature, and not have to come to you. But our goal is to be creative, do something different, incorporate a new housing type into Volusia County. And so we wanted to bring this forward, and we are decreasing from 196 to 135. So the concept plan you have in your packets is correct. It shows 135 units, and as you see, they're clustered kind of in certain corners to make sure that we're preserving as much of the wetlands as we possibly can. We have 0.27 acres of direct impacts to the wetlands, and that is for the stormwater pond to the south, as well as one of the road connections that we're required to produce to kind of include everything as one cohesive unit. So those are kind of the only impacts that we really have to the site. And we have about 70% open space and 20% common open space. And our impervious area is about 26%. So really small amount of impervious area, trying to cluster as much as we can and preserve the wetlands that we can as well. Move it on, please. Thank you so much. I think that's kind of what I went through. We have a nature trail, a dog park, a playground, an exercise room. So we really tried to up the amenities we have in this area and provide for various services for the residents. Can you go to the next one, please? Okay. So these are the elevations of the housing types that are a little bit different. They're 1-story and 2-story, cottage style. Most of them are going to be 2-family. We have a couple that are just 1 unit, so just 1 family, that are closer to the single family residence that you'd see, but most of them are going to be what you're looking at here, which is the 2-story, 2-family type of units. And I think that's about what we have. And so, honestly, we've been working with your staff. A lot of that green area that you saw on the concept plan, we did have units in. And your staff came back to us and we worked together and said, look, we need to up the open space. We need to preserve more wetland. What can we do? And so we went back to the drawing board. We have our engineer, Luke Killick, here, and attorney Mark Watts. I brought him as a pretty face. But our goal is to work with your staff and to bring forward the best product that we can. One, that is actually lowering the density from R4, and two, that is dramatically reducing the traffic generation in this scenario. The traffic counts were from 195 units, which would still be lower, but now we're at 135. So we're lowering it even more than that. So I'm really proud of this product. I'm proud of what your staff has done in working with us to ensure that we have all these amenities, to ensure that we have all this common open space, and to kind of bring forward the best product that we can to our residents. So I'm happy to answer any questions, and I'd love to come back and rebut as well if possible.
Mr. Costa.
I have a question for you. Can you go back to the last slide before this one? That one right there. So educate us, because I look at this and I see an apartment. You're calling it a cottage home?
So the style is cottage home. It's typically, I'm not an architect, so I'm not the best I'm not the person to explain this to you. I did Google it recently, and I was like,
Google knows all, right?
What is the difference between a cottage style home and a regular style home? And it's the architectural style of it. So typically they're a little bit smaller. The roof types are different, and now I'm getting into words I don't know. The pitch is lower, and the look of it is a bit different.
So they're not single-family homes. These are rental. This is a rental complex, or is it a to-own complex? It's a rental complex.
Mm-hmm.
Okay, that's what I was trying to get to. All right.
And so it's more. So in your code, what it really looks like is your code calls it two-family.
Yep, I gotcha. Okay, now that makes more sense to me. Thank you.
Mr. Phillip.
Yep. You answered that question because I was going to ask if it was going to be owned by someone and then rentals, and I want to come back to that for a second. But I do want to talk about the site plan. Can we bring up this picture really quickly? Thank you. Let me say that I think that it's heads or tails above so many things we've seen. The one question I would have, your Minnesota Road access point at the lower south end part. I don't know if it's south, but yeah, I guess it is south. Right there. From looking at it and seeing some pictures and everything, I think that those wetlands drain across there. Mm-hmm. That would be my one say. Is there a different place that could be, or is there any type of mitigation? Because I mean, I think I have a picture of it right now where it's underwater right now, or the south side of Minnesota is underwater right now. And I just look at it as potentially doing, again, maybe not. I'm not an engineer. I'm just bringing it up that one particular access point looks like it could be, because the wetland dips down right there. It's just something I bring forward as a concern right now, since water is a concern. And looking at it, if there's a potential to move that around, I kind of put that out to you, because I do think that could be a problem. You know?
Mr. Feller, I'm not very good at math, so I'm definitely not an engineer either, but we do have a professional here that can answer those questions, and I know we've done some mapping, so we may have already looked at the stormwater and where things are. So, Luke?
Luke Kulich, 300 Interchange Boulevard, Ormond Beach, Florida. Our goal was to line that driveway up with the cross driveway off Minnesota Avenue. Mm-hmm. We'll go back to the drawing board and make sure that's the case. And if there's a crossing, culvert or any other systems in place connecting wetlands, we will avoid that. And we'll move the driveway further to the east if needed. But again,
I think from my side, it would be good just to say that, I mean, we always talk about what you're responsible for on your own piece of property, but then we also talk about the neighbor saying, well, the development just flooded me. Just something to think about for those southern properties. As you're looking at it, I mean, it does look like it's potentially where wetland would go through, and under, not that you're responsible for the road, but I just bring that up as a concern.
Thank you.
And then the only is your applicant, so this is for you. I'm going to say this out here. I'm not asking you to do this, but I would say this. There's always talk about affordable housing. This is one of those types of developments where I think I've seen other counties and other places look at a builder coming in and saying, I'll reserve a certain number of units for affordable housing. I actually kind of like these cottage style houses for something like that. That's all I'm going to say about it, because affordable housing always falls back on the single property owner in Bethune Beach, and then all of a sudden we're doing. So just something to think about if you're talking about, what did you call it? Being creative on your design. Just something. Thank you.
Thank you. Appreciate that.
Thank you. Okay, we have one participation, and we will give you an opportunity to come back for rebuttal. Wendy Anderson.
Good morning. I'm Wendy Anderson, and I live at 505 East Victoria Trails Boulevard in DeLand. I am a professor at Stetson in environmental science. I am also your elected chair of the Volusia County Soil and Water Conservation District. Although I'm not speaking on behalf of them, I do know something about soil and water. So anyway, I'm here today. First of all, I mean, Richard Feller, Mr. Feller just stole my thunder. Thank you for that. I do want to give kudos to this project. I'm really excited to see the sort of thoughtful consideration that's gone into the multifamily and diverse housing types that are in it. I love the clustered development that they're doing here. This is exactly what we need and what's appropriate for, for what's going on along 472 and the development that is coming that way with the Southwest Activity Center. I wasn't going to come this morning to talk about it, and I'm here and missing a meeting somewhere else to say this. On my way here, I drove down Minnesota Avenue because I was curious how it looks right now. I live in Victoria Park. As I walked in earlier, somebody was referencing the flooding going on around Victoria Park right now. I'm going to come back to that in a second. So I was like, well, I wonder, can we go back to the first page, the location slide? So I was kind of curious, you look at this picture, there's a lot of water to the north. And on the DeLand Ridge, the DeLand Ridge is the highest ridge in Volusia County, and it tilts to the south. And so water is flowing from north to south here. And it's flowing, ultimately underneath 472, and it's continuing on to the south. And so I started thinking, are we, we have an opportunity right now after this, what we're calling 500-year flood, which I can guarantee you is going to occur more frequently than once every 500 years. It will. So here's an opportunity right now to really evaluate this site. I speak to the civil engineer sitting behind me. Please evaluate this site very carefully for its current flood state. Please move that entrance road on Minnesota Avenue to the east or the west. I took a picture of it on my way here. It is flooded, so I don't know, build a bridge or something there. Your neighbors will be stuck in there. And then also, the property south of Minnesota Avenue is flooded. The road was flooded. There's still debris in the road. The road has been flooded within the past week. The Jehovah's Witness church just to the east of that road clearly had water standing in their parking lot. There's a mobile home park just there behind that wetland on the south side of the road that's clearly had some water in it. We're going to be impacting the hydrology of this area quite a bit, even by developing in the uplands. And so I just ask, again, I think the project is really good, but I ask that the civil engineer take a very, very serious look at the conditions right now and plan for that.
Do we have any questions?
The only thing I'll say is I may have stole your thunder, I'm sorry, but you're my source of information. So thank you for providing me with, and I did disclose that as ex parte about that. So thank you very much.
Absolutely.
Something I'd like to say is, I'm glad you came up, Wendy, because I've had several friends that had RVs in KOA campground. They had to move them. They're flooded. So, something to think about.
Thank you.
Thank you.
Yes, come on up because we haven't closed the public hearing. And as soon as you do, would you fill out that form and give it to the staff, please, sir?
My name is Louis Emmer. I currently live at 755 East Minnesota. I work at 1440 East Minnesota. That is the campground. I've been there for over 40 years. Ever since Arvida was built, we have flooded. We used to not flood like this. It has gotten worse. They currently pump from the golf course down behind the T.G. Lee Dairy. It goes into the French drain right there, floods into that property. That picture right there is very inaccurate. My brother right there, he's on that yellow line. We have a fence that goes around our whole 9 acres where we live. The fence is underwater. It's not 6 inches, it's 6 feet of water. That never used to happen in the 80s, 90s, 2000s until Arvida was built. They have caused this. It has to be fixed. I'm not against them building something there, but there's a lot more to do than just a little flood control. This is a serious problem. The campground right now, the water since the last storm has already risen 6 inches. It keeps going up. It doesn't go down. It won't go down probably for another 2 to 3 weeks. Minnesota will be flooded. Right there where my pond is on the campground, it's almost across the road right now. It's already deteriorating the road a couple places where the banks caved in, and it's like 4 or 5 feet deep there.
Can I ask a question, sir?
Please.
So you're the pond that's right down, that
So,
you're on the corner of
so when
Minnesota
you look at
and
the very corner on, like on your left of
Yep.
that,
Yeah.
that's my
Yep.
brother's house, you can see right there.
Yep.
That pond that looks like a boot
Yep.
is the campground
Yeah.
pond. That pond is 3 times that size right now. That picture is not very accurate, as in over even 2 months ago.
I think
before
that's where
Ian.
I'm talking, that's where the flooding is today. Like
flooding-
the standing water is still there today,
The
right?
flooding goes all the way down almost to the end to 472.
Gotcha.
I mean, it's literally all the yards, every family, every septic tank is underwater right now. Okay.
Thank you. Mr.
Mr. Bender, if you want to see
This
Mark's
is-
face more than mine, that's totally fine. I can bring him up here.
Don't believe that for not 1 minute.
That might change the billable hours.
I appreciate the comments from Wendy and from the neighbor as well. 100%, we have our civil engineer here taking notes about it. So we are going to look at that. And again, we're in the very beginning stage. We're in the rezoning stage. At site plan, we're going to have to go all the way back through this process and do the actual engineering and look at all the surrounding properties and what's going on with the site specifically. So we're going to look at it, already written down to look at. So no problems there. We'll definitely make sure we take a look at it and ensure we're not doing anything to impact any other areas. If anything, hopefully try to help some of the situation.
Thank you. We are now going to close the public hearing and look for commission comments or a motion.
I'll be glad to make a motion that we approve case number PUD 23002, subject to the one staff condition.
I'll second that.
Approving to forward this to the county council?
Yes, sir.
Okay, it's been moved by Ms. Shelley, second by Mr. Young, that we forward the rezoning application of case PUD 23002 to the county council for final action with the recommendation of approval. All in favor, say aye.
Aye.
Any opposed?
No.
It's 5-1 with Mr. Sixma against. Thank you. First, let me ask the commission, we have quite a bit left to do. Now, are we going to work through this today? Are we going to be looking to take a 30-minute lunch break kind of thing, maybe in a little bit?
The rest are all pretty much variances except for the
Wanna
the
walk
one
through
ordinance. I'm ready to plow.
Let's
if you
keep
guys
going
are.
through it. Okay, so with that,
Mr. Young?
with that said, Mr. Young?
I was just going to say that most of these, though, have multiple variances within them, and that could cause a lot of discussion. So we
could
need to think
readdress
about it.
We could readdress it once we get down the road a little bit, but what I would ask for right now is everybody to be patient with me. Let's take a 5-minute break because my cup runneth over.
Yeah, I have a feeling there's a couple of them here that may run into time.
Good, thanks. Just wasn't sure if you were charging for your pretty face. Just kidding. Yeah, she's terrific.
I'm the guy that was saying
Thank you.
Yeah, that's not you. Yes. I know, yeah. Crowds cleared out. Okay, so Mr. Bender is, oh, I noticed he was there.
She said that she's in the office. She's looking at key cards between 3 and 4 today. So were they? She said you're more than welcome to swing by. She's in the historic courthouse. And there's 131. I'll double check. Sorry, I gave the right room. But she'll help you out. is more participation. I've set them up in.
Oh, and Mr. Feller's going to make us late for the.
Pardon?
This feller's going to be ready to be back, and he's going to be out. Over here, Mr. Feller.
You cold?
I'm freezing. And I'm normally not. I'm normally hot in here. And I'm wearing a knit dress. I just thought, didn't think I'd need a jacket today. But we'll need one tonight, that's for sure.
It is a little cold.
Yeah, the guy over there said it was
But
cold
it's
too.
the dampness. The dampness too carries the cold.
Yeah.
It eats through you. You know, you can have the
I
same.
like being cold, actually. I like cold weather better than hot, but I like to have a jacket on.
But you know, you can have this. Gave a weatherman when we were talking. I gave a talk one day. You can have the same temperature, and you can change the humidity because the humidity is what the water in the
That's
air.
what gets it, yeah.
And you can have the same temperature and have a near zero humidity, and then you can have a same temperature with a very high humidity, and you'll feel a lot colder because of the difference in it. Remember, a fan. You realize that
Let's get ready to get started here.
a fan doesn't get temperature cooler.
Yep, that's true.
Whoops. No, it was a cool weather.
Okay, do we know where Miss Smith might be? She's back. Okay. The November 17th, 2022 hearing for the Planning and Land Development Regulatory Commission will come back to order. Ms. Shelley, may we have the next case, please?
Yes, sir. Case number V-23-006, variances to minimum yard requirements to construct an accessory structure on prime agriculture A1 zoned property.
May we have the staff report?
Good afternoon, Ben Walter, Planning and Development Services. This variance request is for an 1,800 square foot detached residential accessory structure. It's a carport garage. The variances there's three separate requests. The first is to reduce the north side yard from 50 feet to 30 feet. The second is to reduce the south side yard from 50 feet to 32 feet. And the third is to reduce the rear yard from 50 feet to 15 feet. This property was vested under the McCormick Unrecorded Subdivision in 1994. At the time, the property was zoned A3, which has a minimum 1 acre in area. Later in 1994, the property was administratively rezoned to A1 to be consistent with the adoption of the comprehensive plan. This rezoning reduced the buildable area of the parcel as the A1 has larger yards than the A3 zoning classification. The original request to the southern yard setback was 45 feet, but there is a drive on the southern side of the property. Bear with me. that serves one parcel to the rear. And so we are, to meet the zoning ordinance, we're measuring the side yard setback from the edge of the traveled way of that drive, which is 32 feet. Excuse me. The setbacks for an accessory structure over 500 square feet are 50 feet on the side yards, and with the width of the property being 105 feet and the additional reduction from the traveled way of the driveway, it does not leave a buildable footprint on the property for any accessory structure over 500 square feet. The reduction to the rear yard, which would be on the east side of the property, is requested by the applicant. As they stated, there's an oak hammock at the center of the property that they wish to retain. The applicant has received letters of support from the adjacent property owners to the north, south, and east. After review, staff recommends denial of variances 1 and 2 as they fail to meet one of the 5 criteria. The structure could potentially be smaller, thus reducing the request for the variance. Variance 3 fails to meet 2 of 5 criteria as the oaks could be removed and replaced and the reduction to the rear yard setback would not be required. If the PLDRC finds evidence to approve, staff recommends one condition, that variances 1 through 3 are limited to the size and location as shown on the variance site plan. I'm available for any questions.
Mr. Costa.
Mr. Walter, so was administratively rezoned from A3. What are the setbacks for A3?
A3 it's a 40-foot front yard and rear yard and a 25-foot side yard.
So basically, these variances wouldn't be required except for number 3 under A3, correct? Okay. All right, that's what I need to know. Thank you.
Anyone else? All right, thank you. Would the applicant please come forward?
Hi, my name is Elizabeth McCormick at 2851 Marsh Road. Thank you for all having me today. Sorry, a little nervous in front of people. Thinking about this project that we wanted to do, so before, back there in that area, there used to be an old house that my father and his family grew up in. We took that out because to us it was a hazard to our daughter and our animals, and we cleared the underbrush.
Can you pull the mic a little closer, please?
Yes, sorry. So we wanted to put a detached garage up there so we could house our boat and things like that. So the size of the shop we would like to keep. Again, with our conjoining neighbors next to us, we have their approval that they would like for us to do that. I did have a question, and I don't know if somebody can answer it for me. I've been trying to get it answered. I know that the A1 or the A3 to A1 took place in May 4th of 1994. When we built the house, everything that was signed off on the house, though, on the plannings and everything, show A1/A3, and it was signed in September 20th. So I don't know what the A1/A3 means. Like, was it supposed to go back? Was it because it was originally? That's what I'm really confused about. And I have the paper.
Can someone from staff address that, Ms. Smith? Are you familiar?
I'm sorry, could you please repeat that question?
So on all the plannings and stuff from when we built the house, I know that the original adoption of everything took place on May 4th of 1984. But the plannings and everything for the house that was built on the property all started, this first one was in July of 1984, which was after May, and everything says A1/A3. I have the paper if it would help.
We'll have to look into that. And if you just can give that over to Ben, Ben can answer that question for you.
I did come across that document, and my guess, I didn't do a thorough investigation, is that possibly the application for the house was in before the rezoning, and so they may have reviewed it to those rules, the A3 rules, before the administrative zoning.
Well, I also have a letter that my dad wrote when building the house to the county saying 2 years ago he had approached zoning about putting another modular home on it. They didn't have the funds at the time, so they waited. So then he sent this letter in because he was told it was now A1 and he would have to put an actual home on the thing and couldn't do a module home. So I have a feeling it might have been after, but.
And that would be consistent with the, I'm sorry, a modular home, an A1 currently would not require a special exception or anything. A second home, though, would not be permitted unless it was an accessory dwelling unit.
Yeah, it was, the letter was sent in August to get everything done. It says it's subdivided. We have been rezoned as A1 and not A3. So we couldn't put a trailer manufactured home that they could only put an actual house on it. So I don't know, that's what I mean when I get confused with the whole A1, A3, especially with all the designs and everything that were done through the county to get the house built. Everything says A1, A3. That's what I was just like confused about. I wasn't sure, like, were we supposed to be changed back to A3 after we did that? Or I don't know, I'm sorry.
No, ma'am, you would need to meet the current zoning code.
Okay. So then that's my.
Okay. Any questions?
I have a question.
Ms. Sherman?
And it's just a clarification question, and I heard you say the word shop, and somehow in garage, is there a shop existing already?
No,
Oh,
there's
okay.
nothing there. So there used to be an old house that
Okay.
they all lived in that was back there, and it was kind of like a hazard, so we took it out because we
Yes, I
didn't want
heard-
to
okay.
collect.
Perfect.
creepy
I guess
crawlers.
my question was, so you're doing a garage?
A detached garage.
A detached garage, because I noticed on the letters of, that your neighbor signed in support, it says, "I am good with the shop being built."
That's my.
Oh, just,
It's
okay.
a
I mean, I'm
garage.
not saying
It's
you
a-
can't have
yeah.
a shop.
No,
I
no,
just
no. It's a
was asking for
it's
clarification.
detached garage so that we can house like our boats and
Okay.
outside equipment, stuff like that.
Thanks. Perfect.
Any other questions for the applicant?
Yeah, is there an existing foundation at all from the old shed or not?
It's all, yeah, I mean, there wouldn't have to be much to be put down as far as if you're talking about as far as like bringing it up any.
Well, I'm just saying where the old shed was, you said you took one down?
So that house was originally, if you look at the picture, the house to the south of me, that originally sat there, and when they brought that house in, they moved it over to our property. So it was just sitting on the back of the property.
Gotcha.
Okay, thank you. We will give you an opportunity to come back. We have one request to speak, and then if you would like to come back and do a rebuttal, you're welcome to.
Thank you.
Deborah Virgin?
Hi, my name's Deborah Virgin. I live at 2825 Marsh Road. Danielle is my niece. And to clear up some things, I was raised on this property. My mom and dad had 10 acres of land. They subdivided it in 1974 and sold my aunt and uncle some property. And then in 1983, the place where their house is was given to somebody, and it was written up, subdivided there. So there's 3 pieces of property. I live on one, my brother lives on one behind us, and they live right next door to us. And there was never a shed before. It was an old house that when I was a kid, we lived in, and it was before any subdivisions was happening at that property. They moved the house that we lived in and got us a decent house with a bathroom. So none of us, it's all family. I don't understand where there's a problem for them to do this. So I support it. Thank you.
Thank you. Okay, we're now going to close the public hearing. I would imagine you probably don't want to come back and rebut that. So we're going to close the public hearing and open it up for commission comments or motion.
I'll be glad to make a motion. I move that case number V-23-006, a variance to minimum yard requirements, be approved with, subject to one staff condition.
I'll second.
It's been moved and motion to approve and second by Mr. Costa to approve variance 1, 2, and 3 with the one staff condition for V-23-006. All in favor, say by aye.
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 Any opposed? It's passed unanimously. Ms. Shelley, may we have the next case, please?
Yes, sir. Case number V-23-007, what am I looking at here? Variance to maximum fence height on urban single-family residence R5 zoned property.
May we have the staff report, please?
Hi, good morning. Steve Shams with Planning Development Services. The property of this application is R5 zoned on a corner lot. The applicant is seeking 3 variances to install a fence in the property. Variance 1 is to increase the south front yard fence height from 4 to 6 feet. Variance 2 is to increase the west front yard fence height from 4 to 6 feet. And variance 3 is on the north side of the property, still within the front yard, adjacent to, I believe it's Delaware Avenue or Thompson, is to increase the north front yard fence height from 4 to 5 feet. The applicant seeking variance 1 to install a 5-foot chain link fence and a 6-foot white vinyl fence on the south front yard because of a potential swimming pool. And potential swimming pool, the applicant also believes passersby could look into the backyard pool area. As of now, there are no building permits filed for a proposed swimming pool, and the applicants will utilize this yard as a side yard. Variance 2 is to install a 5-foot chain link fence on the west front yard to contain their dog on the property. Because it is a chain link fence, it would not obstruct the visibility of traffic. And variance 3 is to install the 5-foot chain link fence on the north front yard, also to contain their dog on the property. Overall, staff recommends denial for the variances as all 3 failed to meet 4 of the 5 criteria. The condition on the property is not a special condition, as the lot is typical and does not have any unique features to prevent the applicant from securing the property with a 4-foot fence. Literal interpretation of the zoning code would not preclude the applicant from a 4-foot fence, and there's no unnecessary hardship found on the property. In addition, this is not the minimum variance that would allow them to construct a fence. Staff does recommend a condition that should the PLDRC find evidence to approve that the variances are limited to the location as shown on the variance site plan. And I'm available for comment or question.
A question.
Mr. Feller?
My first question is, the variance, if we do the variance, it's to the location, but is it the type of fence? Because if we do a 5-foot, could it ever be changed? And if it were a vinyl fence, would it obstruct view then? Did you say it didn't obstruct view because it was a chain link fence? But we're not determining what kind of fence, we're just determining height. If it went to a vinyl fence, would that obstruct view and then change our plan? Could we tie this to not just the location, but the type of fence? Because I just don't want to create an obstruction by doing the variance.
Yes, so they proposed a chain link fence, and that's what we reviewed. It's up to you if you want to add that stipulation
But
to the condition.
could they change that, though?
Yeah.
Yeah.
So our variance is just about the height, not what type of fence it is, but we could tie it. I mean, I guess that would be up to the motion.
But whoever the motion maker I would think, specify that it's for a chain link fence, and you cannot change that. I would think that would be the way. Would that not be correct, Mr. Sawyer?
Well, you can, I mean, you can make a determination if you are granting an increase in height, if that height, if the materials are an issue, and would serve to kind of alleviate the damage, for a greater fence height, you can make that a condition. It just has to be reasonable. So
I guess my question was, we have a variance site plan, and usually we make it not based on the location, but says the variance are limited to the location of the fences as shown on the variance site plan. Can't we just say the variances are limited to what's shown on the variance site plan? Because then it does say chain link fence on there. I guess what I'm asking is how can we codify, so to speak, chain link so that it doesn't become something that provides a hazard for viewing?
Would that not come out during the permitting process when they view the lay of the land, as opposed to being a a pervious, or not a pervious, but a obtuse fence as opposed to a see-through fence?
I'm not sure we have any, we don't have a restriction if someone wants to do anything other than a chain link fence unless this commission wants to put that as a specific condition, location, type, and material of the fence depicted on the exhibit.
Wouldn't we have to then address the variances separately? Because of the fact that the one portion where they are talking about a chain link fence, but then putting a vinyl fence in there to cover their pool area. Isn't this the one, as I recall?
I believe it says vinyl on the backside.
Right.
And then chain link
Yes.
on the variance
So
site plan.
my
it
point
actually-
is, so we will have to treat the variances differently, not differently, but separately? No?
Couldn't we just say variance as depicted on the variance site plan, not with location? My question is, can we change the staff
Right,
recommendation?
but aren't we going to allow them to do the vinyl around the pool? Because that also has chain link where they were going to put vinyl in the chain link.
I guess what I'm saying is, I think around the pool, it does say vinyl. On my sheet, at least it does. So if we said,
Okay, but
Yeah.
if you look at the description, there will be a chain link.
right,
And they're putting the vinyl in the chain
that's
link.
the orange. Yeah, the orange is chain link, correct?
I'm just saying.
Okay,
I'm
let's
sorry.
let's do this.
I'm
Let's do this,
There's
because
a
we're
blue-
getting
there's-
a little bit too far
Variance
off to the
one.
left. When the motion is being made, whoever the motion maker is, specify at that time what they are trying to accomplish, and then we can work through that process then.
Mr. Chair,
Mr.
what I think,
The applicant,
what I think that the problem is in variance one, part of the fence is chain link and part of it is vinyl.
Correct.
According to the drawing.
Yes,
So
correct. That's
if
what I
we,
was-
if we handle each one or at least vinyl, the variance one separate, we have to describe that half of it's vinyl and half of it's chain linked.
Okay, let's
Because
do
it's
this.
not stated in here.
Let's do this. Let's do this. Let's have the applicant come forward and tell us what they're trying to accomplish, and then
That
we
was
can
my
figure
point,
out
Jay. Thank you.
how to make a proper motion.
Yeah, that's what you were trying to say, but you didn't.
Good morning, I'm Henry Paisley Jr., address 1153 South Thompson. So the blue line is a vinyl fence for the backyard, and it comes up the side of the house halfway. So it can block the backyard and also for safety. And all of the orange is a 5-foot chain link fence. So it's not obtuse, you can see through it. It would be no problems. The reason I want to get the fence height is mainly for safety also. This morning, the chief of police was on the news speaking about where I live at, the Spring Hill area, and there's been a lot of gun violence there and a lot of break-ins and everything. So I just want to be able to protect my family and have a higher fence. And you can see clearly through and see the house and everything.
Okay, then the question.
Hold on a minute, let's be recognized by the chair before we just.
Okay.
All right, Mr. Young, go ahead, please.
Then you agree that the half of the fence on the variance fence on one side has half vinyl and half chain link?
Yes, that's the back corner of the house.
Okay.
Yeah, it doesn't come up past half of the house.
Okay, I just wanted to make it clear so that we understand that variance has to be stated that way.
Okay. Okay. But that'll be the blue vinyl 6-foot fence. And then the front, the rest of it all chain link 5 foot.
Okay. Are there any other questions? Thank you. We have one request for someone else to speak, and we'll give you an opportunity to come back and give a rebuttal after that. Is it Ms. Steele?
Hi, my name is Celeste Monty Seals. I do have some concerns.
Your address, please.
1124 South Delaware.
Thank you.
I have some concerns about the property, period. I've been talking to him for months about cleaning up the property, my estates. Well, whoever did clear the property off, they took my trailer off my property line, and they cut down a lot of trees and stuff. So I have lots of concerns about that. And they put my trailer on the state's property, off my property line.
Okay, with what you're addressing, that's a civil issue. We're not here to address that. We have no jurisdiction over that. You would have to go through the courts in order to rectify that type
Okay, I
of
will.
issue. All we're here today is to decide whether or not he's gonna be able to put up a fence.
Okay.
If he's putting up a fence and it's not on his property, it's on your property, that's still a civil issue, and you need to
Okay.
deal with surveys and all of that stuff, and that's outside of our purview.
Okay.
Okay.
So I go to the courthouse, right? Do that?
Yes, ma'am, you'll have to,
Okay, I will.
find a legal
Because I have
avenue to
a lot
address
of pictures, so I go to court and do it?
Yeah, you'll have to,
Okay,
probably
that's
have to
fine.
get legal advice as to how to address that, but that's outside of what we do here.
Okay.
All right,
All
thank you.
right, bye.
Okay, there's no other individuals wanting to speak to that, so we're going to close the public hearing and look for a motion or comments from the commission.
I'd be happy to make a motion. In case V 23-007, I move that we approve variances 1 through 3 with the staff recommended condition. But I would say the variances are limited to the depiction on the variance site plan. I don't know that would necessarily location. So I would say the variances are limited to the depiction of the fences as shown on the variance site plan.
I'll second that, if that's the legal description that we can use.
We take the site plan when we review the the fence permits. So, you know, it's supposed to be that half vinyl, half chain link type thing. So my understanding is that is the motion is that you are a condition that the applicant construct those fences according to the proposed site plan.
That would be my recommendation, or my motion.
And my second.
I have a question. Does that go with the property?
Well, if they want to, yes, the variances, so,
Okay,
you
so
know,
if someone else comes in there, they can only still do the chain link? They can't put in a non-chain link fence on the
yes,
property?
yes. If they want to get that increased height,
Okay.
if they drop down, there's no restriction on the material.
Thank you, just wanted to clarify
Thank
that
you.
for myself.
It's been moved by Mr. Feller, second by Mr. Young, that we approve variances 1, 2, and 3 for V 23-007 with the one staff recommended condition. All in favor signify by saying aye.
Aye.
Any opposed? Motion passes unanimously. Ms. Shelley, may we have the next case, please?
Yes, sir. Case number B-23-008, variances to the minimum yard requirements on urban single-family R9 zoned property.
May we have the staff report, please?
Good afternoon, Michael Hansen, Planning Development Services once again. This particular variance, I wanted to let you guys be aware, there was a revision to the staff report that you originally received, so you should have received the revision that included a variance 1 for a substandard lot and revised the site plan. So in review of the particular property, it's zoned R9. The property lot size is actually 4,083 square feet. That prompted the necessity for variance 1 to allow construction on a substandard lot. The property, as you can see from the aerial image there, is developed with a house. That house was a permanent house that was permitted back in 1986. In review of the criteria for granting variance 1, staff made the recommendation for approval, noting that it met all 5 of the criteria. For variances 2 and 3 is for proposed accessory structure, a shed that is 10 by 12 or 120 square feet. In the rear portion of the backyard, the applicant's looking at encroaching into the required 5-foot setbacks to the rear yard and then also the side yard. In review of the criteria, staff made the determination for recommendation of denial, noting that it failed to meet all 5 of the criteria for granting. It only met 1 in that the variance request is likely to be non-injurious to the area pertaining to the variance, because we did receive 3 letters of support from the most affected adjacent neighbors that are included in the staff report. In regards to the other criteria, we couldn't determine a hardship existing to prompt the need to reduce the setbacks from 5 feet to 2.83 feet and 3.62 feet, as you can see on the variant site plan there. I'm available for any questions you may have.
Do you have any questions for staff? Would the applicant please come forward?
My name is Laura Hagan. I own 6833 Turtle Mound Road at New Smyrna Beach. The things you don't think about when you buy your first house. Where to store things. We're just looking to have something nice where we don't have a lot of, land in the backyard. So just trying to make the most use out of it. But at the same time, have a nice place to put our yard equipment. And I don't really have anything too much else to say about it, but.
Do we have any questions, Mr.
One quick question.
Mr. Fellows?
Is this like a prefab shed that you're getting for like a Home Depot or something like that?
It is,
Are you
yeah.
going to pour a slab, or are you just going to put it over rock, or just still on pot? Do you know how they're going to install it?
I don't have that exact information.
It probably doesn't matter, but that area, impervious solutions, I mean, if it's can set right on the ground, that helps with water runoff and stuff like that. So,
Right,
but
yes.
it sounds like it's probably an easy one, so thank you.
Anyone else? Thank you.
Thank you.
We have one. Let's see, is this it? No, we don't. We don't have anyone looking to speak to this case. So we are going to close the public hearing and look for a motion or staff.
I'll be glad to make a motion. I move that we approve case number V-23008, variances to the minimum yard requirements on urban single-family zoned property, subject to the 2 staff conditions.
It's been moved by Ms. Shelley, second by Mr. Sixsmith, that we approve variances 1, 2, and 3 with the staff recommended conditions. All in favor, signify by saying aye.
Aye.
Any opposed? Motion carries unanimously. Ms. Shelley, may we have the next case, please?
Yes, sir. Case number V-23-011, variance to maximum fence height on urban single-family residential R4 zoned property.
May we have the staff report, please?
Hi, good afternoon. This is Steve Shams at Planning Development Services. The subject property of the application is an R4 zone property on a through lot. The applicant is seeking 1 variance to the west front yard fence height from 4 to 6 feet. They're seeking the variance to install a 6-foot white vinyl fence because a potential swimming pool. Again, no building permits have been filed to date, to contain their dog on property and to limit passersby from looking into their backyard area. However, the site plan indicates a 16-foot gate along Monroe Street in the rear yard. The applicant indicated it would be for vehicle access, and they intend to utilize a truck to store their boat in the backyard. So, staff's analysis of this indicates the western yard functions more as a front yard, not a rear. Overall, staff recommends denial as it fails to meet 5 of the 5 criteria. The condition is not a special condition, as the applicant is utilizing the rear yard as a front yard for vehicle access, and neighboring residences do not have fences higher than 4 feet. The condition is a direct result of the applicant's actions, and it's not the minimum variance to improve security of the property. Should the PLDRC find evidence to approve, the staff recommends 1 condition, that the variance is limited to the location of the fence as shown on the variance site plan. I'm available for questions.
Any questions for staff?
No.
Would the applicant please come forward?
Good afternoon. Thank you all for your time. My name is Christine Austin. I am at 2730 Call Avenue. We have moved into this home in April of this year. When we were looking for a home, we were actually looking for a home that would sufficiently be able to park our boat, essentially. Previously, in our previous house, we had available space on the side of the yard to be able to park our boat behind a fence for security purposes with the boat. My husband has some serial equipment in the boat that he's afraid of people, coming in and stealing or whatnot. So we do prefer to have the boat behind a fence. This particular property, we actually liked it because there was access to the backyard, although there was not enough width on the property line to be able to park the boat on either side of the house. We found that we had access through the backyard, through the road that runs along the backside of our road. The backside of our house. That road is an unpaved road. There are homes back there. We've talked to the majority of our neighbors, and none of them have expressed any concern with the fence that we're proposing. We do not live on a corner. There is sufficient viewing that could be had when traveling down the road. I have pictures of where our house is situated and what the view is down the road. There is currently a 6-foot fence that runs adjacent to our property on the south end, I believe. And that fence is a 6-foot fence that extends approximately 6 feet past our property line. Our proposed fence stops at our property line and runs the entire width of the back part of our property. We do not intend to use that area as an ongoing travel, if you will. We've essentially moved our boat maybe 4 times since we've been there since April. We're not looking to have regular parking back there, and we're not looking to essentially have a lot of traffic, if you will. We're just trying to find a place to store our boat. The additional fence height is needed so that we can, keep our dog contained within our yard and so that she doesn't try to jump over the fence. We also have a sliding glass door that looks directly into our living room, and anybody passing by on the road could look over and directly see into our property right now. And we're trying to limit that. We're looking to improve the safety and improve the privacy of our backyard. We do have plans or have discussions essentially to potentially put a pool in our backyard at some point in the next couple of years. I mean, obviously we just moved in. We're not quite at that point just yet, but looking ahead, we would prefer to have a 6-foot fence now because I want to do it right the first time essentially and provide proper security and access as needed for future use essentially.
Do we have any questions for the applicant?
Yeah, you said there's a 6-foot fence now existing somewhere? On the
Yes,
south,
sir.
on the south side, that would be along the neighbor's house, right?
Yes, sir.
Okay.
I have pictures if it helps.
If you're gonna do that,
Leave
you
them,
give it to staff,
yeah.
then
You don't need them
you
back,
won't get
right?
them back. Okay.
In one of the pictures, there is a property marker that you can clearly see up against the fence, and that is our property corner essentially.
So that's a 6-foot board fence?
Yes, sir.
Okay.
That's our neighbor's fence that was there when we moved in. Obviously, it looks like it's halfway fallen
So that's your property
apart.
line where the survey marker is?
Yes,
Okay.
sir. And our fence, we're looking to put up a white vinyl fence all the way around what we consider our backyard. It's been described in the paperwork as an additional front yard, but we don't consider it that, I'm sorry. But we are looking to just put up a fence that runs parallel to the existing fence on the south side. And I don't think that part was in contention. It was the part that was running along the west side. I'm sorry, I'm directionally challenged in my own yard.
West side showing the front.
The west side, I believe, is the part along Monroe Street. is the part that we're here for the variance request for.
Any questions? All right, thank you so much.
Don't forget to just one comment, don't forget to get a permit for the pool when you decide we'll put one in.
Oh, most definitely. I mean,
Just throwing that out there.
No, most definitely.
Because a lot of people
we're here
don't.
because of our permit request for the fence in the first place. So, I mean, we're trying to do everything above board. We're trying to dot our i's and cross our t's and do things the right way. We never imagined we would need to go for a variance request on a fence in a backyard, and at least what we consider a backyard. Didn't even think of the road being a concern, but obviously we're here and trying to do things the right way and just trying to secure our property and secure our dog and maintain the safety and privacy of our property. Thank you all for your time. I appreciate it.
Thank you. We're now going to close the public hearing and ask the commission for a motion or either comments.
I'll make a motion, Chair. I'll make a motion that we approve case number V-23-011 with the one staff recommended condition.
I'll second that.
It's been moved by Mr. Costa, second by Mr. Young, that we approve V-23-001. All in favor signify by saying aye.
Aye.
Any opposed? Motion carries unanimously. Ms. Shelley, may we have the next case, please?
Yes, sir. Case number V-23-012, variances to minimum yard maximum lot coverage and to allow development on a substandard lot on urban two-family residential R6 zoned property.
Thank you. May we have the staff report?
Good afternoon. Ben Walter, Planning and Development Services. This variance is requested for the construction of a 1,792 square foot replacement residence. It totals 5 variances. The first request is to reduce the front yard from 25 feet to 13.1 feet. The second is to reduce the rear yard from 20 feet to 18.1 feet. The third is to reduce the north side yard from 10 feet to 8 feet. The fourth variance is to increase the maximum lot coverage from 35% to 42.2%. And the fifth variance is to allow development on a substandard lot.
Excuse me, Mr. Before you continue, in variance 2, I believe you said 18.8, and it's showing in the staff report 15.8.
Excuse me. Yes, please. Please correct that to 15.8 feet. My notes were incorrect.
Thank you.
So this property is non-conforming and is substandard. It is under 5,000 square feet in area. It is zoned R6. It's an urban two-family residential zoning classification, but it does allow the construction of single-family residences. The owner inherited this property in 2017 in its current condition with the current home. The existing residence was constructed in 1948, which predates the enactment of the Unified Zoning Ordinance, and it could not meet the requirements today as it exists. The proposed home, and let me get to the site plan, it's easy to see visually here. The darkened area is the proposed footprint, and the dotted lines are the existing home. So the proposed home reduces the existing non-conforming yards, except for in the rear where it increases it by 1.2 feet. The new proposed footprint of the home does increase the lot coverage from 34.2%, which is conforming, to 42.2%, which is non-conforming. The applicants are aware of the requirements. Their desire for the larger footprint is that they plan to retire in the home, and they desire this for easier mobility in their retirement years. Excuse me. Staff finds that variances 1 through 4 fail to meet 3 of the 5 criteria. As the zoning ordinance exists, there would be a 30 by 40 buildable footprint area, and we recommend variance 5 be approved as it meets all 5 criteria. If the PLDRC finds evidence to approve, we recommend 2 conditions. One is that variances 1 through 4 are limited in size and location as shown on the variance site plan. And 2 is that vested rights application be completed through the land development activity. And I'm available for any questions.
Any questions for staff? If not, if the applicant present, would you come forward, please?
Good afternoon. My name is Matthew Magnus. The property is 3631 Cardinal Boulevard in Daytona Beach. First, I appreciate your time today. This is my first time being involved in something like this, and I've been very impressed with the way the process works and so forth. I appreciate the opportunity to do this. Just a couple of quick things. There is an existing home there. As Benjamin mentioned, the home that's there currently really is not in reusable condition. We've tried to look into fixing it up or updating it, and it's just pretty far gone at this point. The property itself has been in my wife's family since 1955. My wife, her entire family, her mother, all grew up in the home, and ultimately our goal is to keep it in the family moving forward. We're looking to build a new home, single-story home, simply because currently today there's family members that just can't get around in the multi-story home that's there, the different levels and so forth, and we felt building a home for ourselves as we grow older and so forth, to be able to stay in the home was really our goal. We want to keep it in the family. We have no intentions whatsoever of getting rid of the property and so forth, and that's why we're looking to do this. Lastly, and one of the other pieces that I just wanted to mention, the home that we're looking to build, we did try to keep it as small as we could, but to get the space that we needed, as I mentioned, her whole family spent time in this house, and her father's goal and our goal was to ensure that family can always use the home. We are looking to build ultimately 4 bedrooms, but we're going with as small as we really can do. 4 of the bedrooms, there's a small study in the front that's going to be the 4th bedroom, again, trying to keep it as small as we could in this footprint. The other piece, and Benjamin did mention this also, right now the home that's there really extends virtually from property line to property line, particularly in the width. There's very little extra room. The back is concreted completely. The front has a big concrete pad. There's very little grass. There's very little outdoor space for the property, and we really enjoy the outdoors. We love being outside, and the hope with the new house is that we're going to restore a lot of natural grass and palm trees and stuff like that, both on the sides and in the rear. Driveway, we want to do some type of a gravel driveway or crushed shell or something like that, so that, again, it's natural, it's not concrete. We really want to restore the natural beauty of the area. We're very close to the beach. We're within walking distance to the beach, and we want to keep that, outdoor beachy feel to it. One last thing, and I know I keep saying that, but there is a right of way in front of the home between Cardinal Boulevard and where our property line is. It's between 35 and 40 feet because there's overhead power lines over there. That area we know we can't build on, even though we were looking to encroach to some degree to the front. I did want to mention that we're still a good distance from Cardinal Boulevard because of that right of way for the overhead power lines that are in front of the home. That is it. Again, thank you for your time. Any questions?
Do we have any questions for the applicant? No. Thank you, sir.
Thank you.
We are going to close the public hearing and ask the commission for a motion or comments.
I'll make the motion. In case V23012, that we approve variance requests 1 through 5 with the 2 staff recommended conditions.
Second.
Yeah. It's been a motion to approve by Mr. Fellis, second by Ms. Shelley, to approve variances 1 through 5 with the staff, 2 staff recommended conditions for V23012. All in favor?
Mr. Chair, before we vote, can I make a comment, please,
Absolutely,
real quick? On page 5 of 16, just so that there's no blowback later, he's got it listed as V23-001, which in this case is V23-012. Just a typo. I want to make sure that gets corrected.
Thank you.
Yep. Okay, we're ready.
All right, with that correction being made, all in favor signify by saying aye.
Aye.
Any opposed? Motion carried unanimously. Ms. Shelley, may we have the next case, please?
Yes, sir. Case number V-23-014, variance to the minimum yard requirements on rural agricultural A2 zoned property.
May we have the staff report, Mr. Walker?
Yes, Ben Walter, Planning and Development Services. I want to make one comment on this. The site plan for this project was revised. There was no substantive changes. The language for the recommended condition was changed to be consistent with the report and the rendition letter. It referenced a specific land development permit number, and we just did the generic land development requirement. This variance is to reduce the front yard from 50 feet to 40 feet for a proposed 1,428 square foot single-family residence. This property is zoned A2 and is non-conforming as it does not meet the minimum lot size of 5 acres. In the review, it was a non-conforming lot letter was submitted, and there was common ownership with a parcel to the north. The applicant has applied to have the lot combined and is in the process in the land development activity. This property is approximately 68% has been delineated as wetland. The upland area is on the western edge of the property along Rasley Road, and the applicant is attempting to locate their structure in that upland area. The proposed location was chosen to reduce impacts to the wetlands and the buffer. However, the structure could be smaller as the minimum floor area in the A2 zoning classification is 750 square feet, and the proposed home is slightly less than double that. Additionally, the variance to move the home closer to the road to avoid impacts, it could be resolved through a wetland alteration permit and a DEP permit if alterations were required to the wetland proper. Staff has received 2 emails in opposition to this item. They are available in your package. After review, staff recommends denial as the variance fails to meet 4 of the 5 criteria. If the PLDRC finds evidence to approve, we recommend 2 conditions. The first is that the variance is limited to the size and location as shown on the variance site plan. And the second is that the applicant shall combine the lots through the land development activity. And the lot in question is directly to the north. I'm available for any questions.
Do we have any questions for staff?
I guess I just have one really quickly. So we received a few letters against it, but this is a legal non-conforming lot. They can build on this lot. The only variance that we're doing is 50-foot setback to a 40-foot setback on the one side. Is that correct? So I mean.
Correct. We're not separating non-conforming lots, and they are combining a common ownership lot as part of the process already.
Absolutely. So this is a completely buildable lot with legal non-conforming. Thank you.
Actually, the original lot was vested, and then the common ownership was discovered in the permitting
appreciate the
process.
clarification. Thank you.
Any other questions for staff? Is the applicant present?
Good morning. My name is Zach Brooks. I'm here for Travis, who's the owner of the home, Mr. Spingstoff. I'm actually his contractor.
Could you give your address, please? Your address?
715 Rasley Road.
Thank you.
New Smyrna Beach. So, yeah, the issue is the wetlands obviously drove us forward. We're encroached all the way, I think, through the buffer. We've already had all of our sites and everything developed. We didn't really want to go into the wetland. We're trying to avoid that, and we really only need about 8 feet, which is why we requested the 10-foot closer variance towards the street, and that would really solve every issue we have. That's about all we have for that.
Do we have any questions, Mr. Fellow?
So by moving it this 10 feet, you avoid the wetlands. You don't have to go through the DEP and do any of that stuff. So given 10 feet closer, avoid the wetlands.
Totally.
Love it.
Ms. Shelley?
I just have a quick question, and it's not regarding your application. Just when he asked for the address,
Yeah, I caught that.
it's supposed to be
Your address.
your address.
Your address, right.
Not the application. Do you live at,
Yeah.
are you going to be living at 715?
My address.
Your business.
We need yours, not the property in front of us.
2526 Hibiscus Drive, Edgewater, Florida.
Great, thank you. That's it.
I caught that too.
So did I.
We're catching things
This is
today.
in Mr. Feller's neighborhood.
Okay, any other questions for the applicant?
Now we know.
If not, we're going to close the public hearing and look for commission comments or motion.
I'll go ahead and make the motion.
Mr. Feller?
My neighbor here. In case V 23-014, that we approve the variance request, and with the step condition.
Second.
Wow.
Yeah, quick one, you're ready to go.
Okay, it's been moved by Mr. Feller, second by Ms. Shelley, that we approve B 23-014 with the staff recommended conditions. All in favor signify by saying aye.
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 Any opposed? Motion carried unanimously. Ms. Shelley, may we have the next case, please?
Yes, sir. Case number V-23-015, variance to reduce minimum yard requirements on planned unit development, PUD zoned property.
May we have the staff report? Mr. Shams.
Hi, good afternoon. Steve Shams at Planning Development Services. This application is on a PUD zone property in Quail Hollow subdivision in DeLand. The applicant is seeking one variance to construct a room addition to an existing home. They're reducing the rear yard from 30 feet to 20 feet to construct a sunroom on an existing concrete slab. The concrete slab was part of the home's original construction, but not subject to setback requirements because it was not a developed area. The home was built to PUD standards, and the decision to add a sunroom is not a special condition. The condition is a direct result of the applicant's actions, and the literal interpretation would not prevent the applicant from building the sunroom on other locations on site, so there was no unnecessary hardship overall. Staff recommends denial as it fails to meet 4 of the 5 criteria for a variance. However, should the PLDRC find evidence to approve, staff recommends one condition, that the proposed structure is limited to the 22-foot by 10-foot structure as depicted on the variance site plan, and I'm available for comment or question.
Any questions for staff? Would the applicant please come forward?
Good afternoon. Well, it's good morning earlier. Ed Sinez, 720 North Volusia Avenue, Orange City. I'm representing Mr. Whitehead here for, I didn't think he was going to be here because his wife's pretty sick. But as you know, Quail Hollow is a very old subdivision, probably the 70s, I would say, it was done. They actually did good during the storms, where he's at kind of high and dry. But if you'll notice, the lot size of his lot is 17,000 square feet. He bought 2 lots and combined them to build his house rather than just a standard lot. So when the slab was poured, when the house was built, of course, you assume, that's something we'll talk about later too, is what y'all need to do with everybody with their subdivisions and setbacks. Okay, I'll get into that later. So he assumed he could do the sunroom. The HOA has no problem with it in Quail Hollow. Okay, I think we already have a letter from them stating it was not a problem because there's been a lot of odd-sized lots out there. It's not like a cookie cutter subdivision. If you've been here for a while, there's only a couple of roads and it's really cool out there. So in the condition that we really have is his wife's sick with cancer. That's why I didn't think he was going to be here until we met outside today. And, you know, he's got a beautiful place out there, you know, existing slab, so it's nothing pervious going on. It's already been like this. We could do a 4th wall system, which are proposed to beam like we have to do on manufactured homes now, and then add it on. And heck, I could go within 5 feet of the property line if we did that. It is an alternative that we've done on other homes, but he'd rather not have the 4th wall. You have to do a post and beam at the house, and it connects to that, and the only thing tied in together is the flashing. So, you know, built and moved in the house in 2016. So we're just, you know, with the size of the lot that he has and what the purpose of the job, in fact, we're like months out on jobs, but this is one that we would get done immediately for him because of the situation he's got going on. If you have any questions, feel.
Any questions for the applicant?
Yeah, what was on the existing slab before?
Nothing, it was a brand-new house, they built in 16.
Okay.
So they put the slab in when they built the house, showing it on the blueprint.
Right.
And of course, you would assume
So
that you
it's
can
been-
build on it, you
Right.
know?
Oh, yeah.
In fact, if you give me 1 minute, the subdivisions all in Volusia County, every city and every municipality, all your setbacks are all different in these subdivisions. As a contractor we do aluminum sunrooms. It's not a brick or block or anything sunroom we just do aluminum work. But we can never get a feel for our poor customers, you know, some that can't do anything, they go 5 feet solid roof and 10 feet screen roof, but they don't know it buying the house. You know, the realtor doesn't tell them, the developer doesn't tell them, the builder doesn't tell
Hey,
them.
why are you pointing at me for?
Oh, I thought you were a realtor, that's right, you retired, you're counsel now, that's right.
Take it for the team, Stoney.
But it's something, I think I brought it up here before, I can't believe that there's not I know that you can't have a standardized size because of the setbacks and all the different subdivisions, but someone should tell the customers, you know, hey, this is all you can do later. You know, I mean, I feel bad for people, you know, not that I need to sell the job, it's just, you know, anyways, my 2 cents. But this is Mr. Whitehead here, he'd like to say a little bit. Thank you.
Stephen Whitehead, 2004 Quail Hollow Drive. You have to forgive me, this is difficult for me to talk about. I retired here in 2016 with my wife in August. In October, she was diagnosed with stage 3 breast cancer. Through all the processes, she made it through that, and then it metastasized to her brain. And she's now bedridden. So I can't get her out of the house anymore. I have to use a lift to get her in a chair. This room would be able for her to go out in the back and still see the greenery and feel the breeze. And it would protect her from the sun and the rain. So I respectfully request that you approve this variance so that I can give her some quality of life before I lose her. I'm sorry.
Thank you for being here.
Mr. Stephen Whitehead. That was him. Okay, you got me there messed up. Okay, I had Ed's in it. Didn't need those. That's what it is, because you were the applicants, you didn't need to fill those things out. Okay, we're gonna close the public hearing and look for a motion or,
I'm ready to make a motion.
go right ahead, please.
Case number I move that we approve case number V-23-015, the variance to reduce the minimum yard requirements on the PUD zoned property, subject to the one staff condition.
I'll second.
It's been moved by Ms. Shelley, second by Mr. Costa, that we approve V-23-015, with the staff recommended conditions. All in favor, say aye.
Aye.
Any opposed? Motion passes unanimously. Next case, please.
Yes, sir. Case number V-23-016, variances to the minimum yard requirements on rural agricultural A2 zoned property.
May we have the staff report, please, Mr. Walter?
Yes, sir. Ben Walter, Planning and Development Services. This request involves 4 separate variances for 3 existing accessory structures. I'm going to go to the site plan to make it clear. Variance 1 is for what is labeled as Structure A, is to reduce the front yard from 50 feet to 47 feet. Variance 2 is also for Structure A, and is to reduce the side yard from 5 feet to 3.1 feet. In that, the side yard setback in the A2 is reduced to 5 feet for accessory structures under 500 square feet. Structure B, it requires 1 variance. It's a 115.3 square foot shed. The requested variance is to reduce the side yard from 5 feet to 3 feet. Structure 3 on the south side of the property is a 1,092 square foot pole barn, and the requested variance is to reduce the side yard from 25 feet to 18 feet. And that 25-foot setback is because it exceeds the 500 square foot threshold. The applicant obtained this property in 2003, and all 3 structures were subsequently constructed without permits. The applicant is working with code compliance to resolve these violations, but to retain these 3 structures, variances are required. The structures could be moved to meet the yard requirements. The applicant states that she has mobility issues and wishes to keep the structures in their current locations for easy access. Upon review, it was determined variances 1 through 4 fail to meet 4 of the 5 criteria. If the PLDRC finds evidence to approve, staff recommends 2 conditions. Variances 1, 2, 3, and 4 are limited to the size and location of the structures shown on the variance site plan, and the applicant shall apply for after-the-fact permits for the unpermitted structures within 60 days of approval of the variance. Another note, environmental permitting supports this request as long as no wetland buffers are altered. That'll be determined during the permitting phase, the after-the-fact permitting phase. A last additional note, the applicant has contacted staff and stated she is unable to attend the meeting today as she is sick with the flu. I'm available for any questions.
I have one question.
Mr. Feller.
Did the applicant build these, or were they pre-existing?
They were constructed after she obtained the property.
After so she did build them?
Yes, sir.
Okay, yeah. Well, but I mean, yeah, I'm clarifying.
Any other questions for staff? Is there any reason why we give like 60 days for someone to come in and apply for a permit? And it seems like if you get approval, you should be able to get something like that done in 30 days and get it over with. Is there any reason that we give such a long period of time?
That's up to the purview of the commission. It's just, yeah, I think that accounts for any potential delays, because it's you have to apply and actually obtain the permit instead of just make an application for it. So statutory timeframes are 30 days for us to issue the permit. So we kind of give them twice the statutory time frame in order for them to comply with the condition of the variance.
Okay, I was just looking at it and thinking they have that long before they have to even come in and submit the application. That's the way I'm kind of reading that.
I'm sorry, I didn't mean to cut you off. If I may, I was going to just shed some light on that. From a development standpoint, right now especially, you can't get a survey to come out for at least 3 to 4 months. They're that backed up. So even the 60 days they may have to come in and ask for an extension on that if they need a full survey, boundary survey done on the property to submit for those permits. That could stretch them out 3 months or longer. Now you're getting to the holidays, so, and plus we just came through the storm season. Everything just keeps backing up. So I think 60 days is a sufficient amount of time. I don't think it's an excessive amount of time. But I understand your point, is that, yeah.
Do they have that long just to come and submit the application, or this is saying have it done? I'm saying, if it's not saying have it done or submit it, then I'm okay. I was just wondering, why you couldn't leave out of here and go right over and submit the application.
This is an after-the-fact permit. These structures are there, and they will be required to provide engineering documents, so they may need to get those done before they can apply.
Okay. Thank you. Okay, there's no one here to speak on this issue. Ms. Shelley?
I have a question. Just for a point of, I'm not a big one for after-a-fact approvals. I guess one of the questions I have on this as well is, these were because of a code violation. Was that reported by their neighbors? Or was someone just coming out and it just happened to catch it with a drone or something? I'm thinking this could be a neighbor issue.
I think it was triggered by a pool. They pulled a pool permit.
Oh, that's in here.
Yeah,
Yes, it is in here.
I
You're
think they
making
did a
my
site
brain go
visit
off.
to
Thank
find
you.
that, yeah.
That's right, when they wanted to do the pool. Okay, thank you for that, Mr. Feller. Thank you.
Yeah.
Okay, great.
Any other questions? We have no request for public participation. We're going to close the floor to public participation and ask for commission comments or a motion.
I'd just like to make a comment, if I could. Here we go again, though, having somebody that's did quite a bit of work in their property without permits, and I'm always against forgiving after the fact when there's no reason that they couldn't have. I'm just putting that on the floor for my own personal, is that they did quite a bit of construction here, and somebody seems to think they didn't need permits.
Mr. Fellow.
I take that into account as well too, and I look at, this is a 5-acre parcel. They built some small outbuildings and a pole barn. I mean, I don't look at those as, you know, I mean, I know that there's permits, especially, I mean, ADUs, and it sounds like they were doing the permits with the pool, which is what's triggered this, so.
At least they were getting a pool
Yeah,
permit.
I am too. I side with both Mr. Young and Ms. Shelley that, you know, I don't like after the fact permitting, but on 5 acres with accessory structures that are relatively small, I think the first 2 were within, they wouldn't even be needing this if they weren't in the setback, is that correct? So, I mean, I feel like if they weren't in the setback, we wouldn't even be talking about them and just legitimizing them. So I'm with you, I agree, but I also think this is, you can reboot.
Mr. Chair, I'd just like to know then, you know, we forgive on a 5 acre. How about a 2 acre or a 1 acre? You know, this is my problem, is that we keep doing this and expanding it, and people hear this and then they decide to go ahead with it.
Different.
Well, I guess too, I have another question, and the applicant's not here,
Ms. Shelley. Go
so
ahead.
she's not able to answer that, but,
Yeah.
you know, do they have concrete foundations under these? Are they Home Depot sheds that they just put on their, you know, can they be, so those are issues that
But we can't
we
answer
can't
them.
answer today.
We could
We
continue
can't,
the case.
and Mr. Chair, if I may. And so we're zoned A2, rural agricultural. So the only thing missing here is an ag exemption, and we wouldn't be having this conversation. And if you know the map, if you know Volco Road and Cross Creek back in that area, it's basically, it is all, it's as rural as it gets, period.
Okay.
Well, I will say, as we're still under this commission discussion, I would hate to see it fail if she's not here to represent herself. So I'll just say that, but I'll also be prepared to make a motion at that point. All righty, well then I'll make a motion in case V 23-016 that we approve variances 1 through 4 with the staff recommended condition, 2 conditions, I believe.
Second.
It's been moved by Mr. Fellows, second by Mr. Sixma, that V 23-016 be approved with staff recommended conditions. All in favor?
Aye.
Aye.
Aye. Any opposed?
Aye.
Okay, there's a 5-1 with Mr. Young being opposed. Ms. Shelley, may we have the next case, please?
Yes, sir. Case number Z-23-002, a rezoning from the prime agriculture A1 zoning classification to the rural agriculture A2 zoning classification.
May we have a staff report, please? Mr. Hanson.
Yes, good afternoon once again, Michael Hanson, Plains Development Services. The rezoning application in front of you is for this particular property off Ranch Road. It is a conforming A1 10-acre lot. The applicant is looking at the rezoning to A2 with the intentions of subdividing the property so that a family member could develop on a 5-acre piece. So they want to create, from the 1 10-acre piece, have 2 5-acre pieces. The future land use is rural, so it is consistent with the rural future land use for A2 zoning classification. There was a rezoning case just across the street that you can see on the screen in front of you. The area that is A2 was rezoned from A1 to A2 with case number Z-07-085, which was approved by council, changing that zoning classification. That's about 170 feet from this particular parcel. Otherwise, the applicants went through a staff review process to get initial comments, so after they potentially have the property rezoned, they'll be working on addressing their access for the second half of the property. It's, with the creation of one lot, it'd be a de minimis impact upon any kind of governmental service. And otherwise, they plan to have the property, the additional lot, served by an on-site well and septic tank based on the approval of the health department. I'm available for any questions the PLDRC may have in this.
Do you have any questions? Mr. Fellow?
We don't know the site plan yet, but access to this, to both lots would still be from the same Ranch Road, correct? I mean, it wouldn't be changing.
Well, actually, there's a rough site plan that they have included in your packets. They're proposing access off of Horsepower Lane, which runs along the east side of the property. However, if you look on the survey, there's also a 30-foot ingress-egress easement that runs along the west side of the property that could alternatively provide access.
On the west side, okay. So Horsepower Lane is also accessible to the property?
That currently runs on the adjacent property. From conversations that I've had with the applicant and based on feedback that they've had with the staff review process, that it sounds like the adjacent neighbor would be willing to give them access to that.
Okay, thank you for the clarification.
So there's no need for us to take into consideration that they don't have an approved easement for that property at this time?
It's, well, but they will have to make the easement, because they own all of it. So, you know, when you separate the property, you should generally, you know, convey that along with some access right. If they can't get the cooperation of the adjacent property owner, most likely they will grant an access easement on the west side of the property to follow along with that existing 30-foot easement, which I think is access for the northern parcel, both for the property to the north of the subject property. So they would have, they have the ability to create their own easement. They would probably prefer to access through Horsepower, but that is a private easement, so they need the approval of the underlying property owner. They're not, I mean, they're creating the parcel, so they have the responsibility for ensuring that that new parcel is not landlocked.
Okay, that's, but I would sure hate that not happen, you know, if that's the only way that they could do it without that. But
One follow-up question to that. Once they divide this, we've got 2 5-acre parcels. Would any of that easement stuff take away from that to make these non-conforming?
No.
Okay, thank you. That's all I care.
All right. Okay, is the applicant present?
My name is William Hallam, 2760 Ranch Road, Lake Helen. Easement, the Gerke's next door on the right side on Horsepower Lane, they own it, and they said they would have wrote a letter or whatever or showed up if they needed to. So we have access to it. And I'm just trying to get it rezoned so I can split the property for my cousin who lives with me with a 7-year-old so he can have his own 5 acres.
Now we know the real motivation.
He's a good kid. He's a real good kid.
It's the 7-year-old.
That way he can be brought up, you know, I mean, he already lives out there, but that way they can have their own.
Okay, any questions for the applicant? No, all right, we're gonna close the public hearing and ask the commission for comments or a motion.
I'll be glad to make a motion that we forward rezoning application case number Z23002 to the county council for final action with a recommendation of approval.
Second.
It's been moved for approval by Ms. Shelley, second by Mr. Costa, that we forward the rezoning application for case Z23002 to the county council for final action with the recommendation of approval. Were there conditions?
No.
No conditions. Okay, all in favor signify by saying aye.
Aye.
Any opposed? Motion Carries unanimously. Ms. Shelley, may we have the next case, please?
Yes, CPA 2112 was continued, so we have CPA, case number CPA-21-013, large-scale comprehensive plan amendment, potable water element.
Okay, Ms. Smith.
Trish Smith, Planning and Development Services. We're going to switch gears a little bit. This is a county-initiated comp plan amendment. Just as a refresher really quickly, our comp plan is our guiding document for the county, and it is backed up by our zoning ordinance and our land development regulations, and that tells us how to get things done. We do have a new committee that was formed by the county council. It's called NRAC, and they will be responsible reviewing any ordinance changes that come forward regarding water and landscaping and low-impact development. In this case,
That's in addition to this commission, so so we're going to have another set of eyes, because this commission is your the local planning agency, the planning and land development, everything has to go through you. So,
Before it goes to county council?
yes, so they're
Whatever we do today, NRAC sees next, and then it goes to county council. This is tentatively set for February 7th.
Potentially for ordinances. Right now, I think they're discussing a lot of things for some of the implementations and changes. What Trish will say is these are necessary state changes that we have to do within a year, I believe. So they're working on essentially a lot of things that came out of the growth management workshop, and they're discussing that this kind of state mandated requirements that we can't wait for this one. So that's why this element is going before this commission.
Okay.
thank you, Paolo. So we are updating all of our comprehensive plan elements to the 2035 timeline. As many of you know, we have brought 14 of them to you over the past 2 years, and we have 3 more elements to update. They all must be submitted to the State Department of Economic Opportunity by October of 2023 for us to remain in compliance with the state requirements. This item did come before you in November of 2021. The PLDRC continued the item to gather more info on water quality issues. We did encourage all members to attend the County Council Water Quality Workshop in early 2022, as well as the Growth Management Workshop that was held in April of 2022. So now we'll talk about this specific item. The Volusia County Utilities serves approximately 7% of the population. So when we talk about this element, we're only talking about that 7% that has to do with Volusia County Utilities. There are 16 public utilities in the county that we coordinate with. For this item, it has been a collaborative review process. It included our utilities team, our environmental management team, and our growth management team. This item was also sent to the Volusia, the VCARD, and the Environmental Coalition of Flagler and Volusia County for comments. Now, just a word on the packet that you received. You do have a staff report as well as an underlined strike-through document. And we also included our matrix, which is the working document that we use throughout the process and includes various comments. And then we've also attached the legislation on page 50 of 50. Any additions you see are in underline. Any deletions are in strike-through. If it's untouched, it's already an approved item, and it's in our current comprehensive plan, and we are not recommending any changes to those at this time. We are required to plan for future growth, and we use population projections from the Bureau of Economic and Business Research Statistics. You may have heard them called BEBR. That is used for any of our comp plan updates as well. So now to a summary of changes in the document. You may notice a large amount of strikeouts at the beginning of the document. In 2009, this was updated, and we had our water facilities plan incorporated into the comp plan. We're now asking to remove that so that we can keep it consistent with our utilities planning documents and the water management documents, and everything now is done on the same timeline and matches. So moving forward, we are working on our water supply facilities plan right now with our utilities division as they're updating their consumptive use permit with the water management district. and those plans will be incorporated as a support document to this document when it goes to county council in the next few months. We did incorporate the new water supply projects to be consistent with our 5-year capital improvements plan and the utility division priorities, as well as the regional plan by the Water Management District. And those projects are listed on page 9 of your packet. Again, we're updating to the year 2035, and we are revising any outdated terms and old agency names. And we have incorporated references into the St. Johns River Water Management District Central Springs East Coast Regional Water Supply Plan. And that uses a regional planning tool, and it's where everybody collaborates to make sure and incorporate all the larger scale projects. So at this point, we ask you to find the amendment consistent with the comp plan and forward to the County Council with a recommendation of approval to transmit to the DEO for review and to Volusia Growth Management Commission for certification. And I'm happy to answer any questions.
Any questions for staff? Mr. Phillip?
Yeah, I do have a lot of questions. I don't mean to be, I know you said some stuff, and forgive me, because I know this is so much work, and I'm just trying to get a few things, but we tabled the sanitary sewer, but in reading it, one of the things I noticed was when it came to wells, there was a certain amount of space, or a certain amount of acreage, and then when it came to septic, it was a certain amount. With sanitary sewer, it's parcels of 2 acres is what they used as the defining for having a septic. But now on this one, wells, it's 2.5 acre parcels. And I only say that because I know it's not something that's new or amended, but when I look through it, I just feel like wells and septics are usually going together. And now we have 2 different standards for what they, like, I guess what I'm saying is, and correct me if I'm wrong, but if you have a septic system and you're on 2 acres, you're okay. You don't have to connect it. But if you're on well and you're on 2.5 acres and water comes available, you're required to connect into it. I personally would like to see that number be consistent with what's on the sanitary sewer one, maybe down to the 2 acres, just curiosity. I mean, probably something different. I'm just bringing
We'd be happy to take a look at that. We aren't opening up the sanitary sewer item today. That was continued.
I know it was continued. So then what I would say is I would like to see that number be reduced by 1/2 acre, just so it's consistent with.
Do you have a specific page reference?
Yes, it's page 22, item C at the top. And really all I'm trying to do there is I mean, again, most everybody I talk to, not everybody, but has well and septic, but now the requirements for connecting are going to be different based on your lot size. So I just think it should be consistent, even though we've tabled that other one. If we're going to pass this, I don't necessarily want to increase it on the sanitary sewer, so I bring it up that I would want that to be 2 acres. So that's one thing. And again, if you found it as 22, page 22, item C.
Yes, sir, we're looking into that.
Thank you so very much. And then 23, page 23, it says, Volusia County shall designate, and this is 7121, Volusia County shall designate a portion of its annual budget to be used for the correction of existing deficiencies in potable water systems. This is probably a bigger issue, 35. Did we hit that mark, or did we miss that mark? Again, I know I'm throwing a ton of things at everybody, and I did attend. I couldn't attend because I was sick, but I did listen online to the water quality. I was trying to get there. And then the only other thing I'll say is, and this was something that I brought up with one of the other developers that was talking today, was it says Volusia County shall begin planning for expanded or replacement treatment facilities. Well, no, that's the 80% of the permitted capacity. I kind of feel like in some of the communications that I've gotten from public on when I've researched the CPA, that they're past that. But the one that I did want to bring up, and I'm sorry, here it is. We just said 7% of this has the impact on just the county, 7% of the county impacts, but there's the interlocal agreements. So I know that it says negotiate necessary interlocal agreements with adjacent cities for purpose of establishing these connections to achieve different water systems and reliability, et cetera. I'll speak to that in a minute, but then the final thing was, the county shall initiate a program with the owners of various private, and there's some strike-throughs in here, shall initiate a program with the owners of various privately held potable water systems serving portions of the unincorporated region to foster coordination, and that's it. So I guess what I was asking is, what is that? I mean, I feel like
Those are private utilities.
No,
So, yeah.
Yeah, I know what
So-
they are. I'm just like, what is the agreement that we're doing? You keep building and we'll keep looking at it. I'm not saying this aggravatingly towards you guys. I'm saying it from if I'm up here as a PLDRC member looking at this as a comprehensive plan change, I understand that there's legal things that have to be done. But these are my concerns as far as potable water in Volusia County.
So I'll try to answer your questions in the order that you asked them, and if I leave some out, please remind me. So, we have a 5-year capital improvements plan that goes before our county council every year, and it always includes water supply, water quality projects. So that is updated every single year. In addition to that, we have this water supply facilities work plan, where we look forward at the projects we need, and those are rolled into our 5-year plan. And then we're also looking at those regional documents and picking up the larger projects, and they ultimately get rolled into our CIP every year. The other document that you all see is we have to review our comp plan every year for concurrency. And we look through to ensure, we cross-reference it against our 5-year capital improvements plan to make sure that all of those things are being done to meet the requirements for the comp plan requirements. So it's an evolving process. It's happening every year. We're looking at every year, 5 years, out to 10 years, and then the long-range items. So it's a constant evolving process. That was your first question. Hang on, I have notes. The replacement, I will tell you, we have a very progressive utilities director. He is out there on the ground all the time looking for grants, looking to identify the needed projects, working with our other utilities to coordinate different projects, constantly updating our agreements with different utilities. And if you haven't ever sat and spoken to him, I would encourage you to meet Mike Ulrich and talk with him one day, and he will teach you everything you ever want to know about all the different agreements we have and how water moves throughout the county. It's very complex. And yes, sir.
Yes.
So again, going back to that water supply facility plan we talked about, all of that information goes into that document, which is where we track all of those items. I think there was one more question you had. 2035 for our comp plan.
Yeah, that's an updated planning horizon.
Correct.
So the answer to why we're changing 2020 to 2035, we're updating our planning horizon. So this is our 2035 comprehensive plan, right? So we're looking out to 2035. Previously, we were looking to 2020. Well, we're past that date. So, it's essentially a requirement that you update your comprehensive plan to go along with your planning horizon. I think it's just a constant reduction. That's.
I would agree, and I guess the only thing I'm asking is, and again, internally, maybe, did we hit metrics? Did we hit our metrics? I mean, I know we're revising the dates on there, but did we make progress, and is this a good goal, by 2035, or are we? The way I read it was, we were going to reduce it 10% by 2020. We did schedule and all we did was 2035, which is not, I'm sure there's more to it than that, but I'm just saying, when I read it, is there something else, or maybe there's nothing we can do, but the way it is.
It's my understanding that our utilities group has met these metrics. They are required to follow the state law and plan for the future. Right. And if we don't meet our metrics, we don't have a consumptive use permit.
Does that include, so would that include the interlocal agreements, or are we not bound by those? Or do we not have to, like if a municipality doesn't hit or doesn't meet standards, does that affect us?
Member Feller, do you mind speaking into your microphone? We're not getting this on the record. Thank you.
Not really. To the extent that some interlocal agreements are, we buy water or they buy water from us, or we buy water from them, and then we're taking from their CUP or they're taking from our CUP. But this is a goal for us to reduce the consumption on the CUP. So that's why you see a lot of reclaimed water, for irrigation purposes and things like that.
Thank you. And I'm sure other people will speak to this. I know we have public speaking here, but I bring up something because I was given something about the city of Lake Helen water, and we have an interlocal agreement with them. and they have not hit their metrics. They've been, they have basically sent a message to their residents saying, our water exceeds the contamination part or whatever. So again, if that's their city interlocal stuff, that what do we have as a county? Because and I'm going to step outside of my role, but if I contact my county District 3 representative and I say, I don't like this, he says, well, that's in the city. I don't have any control over it. Do we have any control over, if the city of Lake Helen has bad water, do we have any control as Volusia County?
No, because they're service areas, essentially, the service areas are covered by under state statute, and the municipalities have control over what goes on in those service areas. So they're usually tied to the CUP, a consumptive use permit, that generates that service area. So we enter into interlocal agreements for reinforcement and things like that, but ultimately it's the municipality who has control over that service area.
And does this document ask for an increase in the consumptive use permit? Is it this comprehensive plan amendment, are we asking for?
No, that's a state permit.
That's a state permit. That's
Sure.
So that there's nothing that okay, thank
Right.
you. I think that's what I have for now.
I got a question. When I was with the Utilities Commission, we had a joint city water task force. In fact, I'm a voting member on the FM, Florida Municipal Utility Association. But do we have that anymore?
No.
Utilities Commission used to be a member. We used to be a member of that.
New Smyrna is unique because their Utilities Commission is completely separate. They're their own government entity. And they don't play along with the city.
Well, that's a long story. I was in the engineering department there.
But here, the utility department is Volusia County. So there isn't a separate entity that sets rates. The county has control over its service area without having to go through, without having to form another coordinating board or another agency.
So that's when a missed over since 1994 when I was a member. Okay, I was just curious if they still honored each other. No, thank you.
Do we have any other commission comments or questions or?
If I can just follow up on your question, because our utilities director must be listening because he just chimed in. He said the county utility has a tiered rate structure for both potable and reclaimed water, where the unit cost per thousand increases as more water is consumed. The utilities division has no jurisdiction over the city's utility department.
Okay, we have one individual in the public that would like to speak to this case. Is that Suzanne Schreiber? I hope I pronounced that right. Okay.
Hi. Stayed to the end, probably getting a parking ticket right now because I've been in the 3-hour lot more than 3 hours. I'm here to ask you to decline the potable water ordinance. On page 40, 7.1.3.2, there is a reference to increasing Deltona's and Southwest areas CUP until further source is available. For a city that approves every development, perhaps Deltona should have considered the weight of their decisions before reaching this point. On July 22nd, the Volusia Forever Committee voted 9-0, denying the purchase of a borrow pit using taxpayer funds that were meant to purchase land conservation. In short, the borrow pit was wanted to help increase the CUP. Had the project happened, water would have been pumped from Mill Lake to the borrow pit and into Blue Spring. To be clear, Mill Lake currently functions as a wastewater retention, or I'm sorry, a water retention pond. Orange City, DeLand, and Deltona Utilities were involved with this project, and before coming to the Forever Committee, they discovered that there would not be enough pumped to be able to make a difference, that they couldn't pump enough. What are we doing with development and water in our county? What is the further source available, which is being called on by the county? How long does that source last? Letter C on the same page talks about reducing water demand 10% by 2020. The new date extends to 2035, as Mr. Feller brought up. Did Volusia meet the 10% reduction by 2020, and what makes the new goal feasible? On page 45, 7.1.7.4, Volusia County should plan before the water flow hits 80% of capacity. Yet the southwest area of the county continues to develop and has gone beyond the 80%. Reasonable people can see our growth is outpacing our water supply, at the very least in portions of the county. Shouldn't cities be required to meet the same water flow capacity? I heard they were separate. Page 46, 7.1.8.1, letter A, negotiating interlocal agreements with municipalities. Did you know that Lake Helen sent notices to the residents on June 27th of this year that their water didn't meet minimum standards for 2 consecutive quarters from 2021? What happened with the interlocal agreements here? And quite frankly, addressing what was said, any city that does not meet minimum standards should be a concern to the county. Look, I have 3 minutes, and there are numerous questions that should be asked concerning this ordinance. I can't cover all the questions that I have in 3 minutes. I question verbiage pertaining to water rates, forced conversion from well to water treatment facilities, water quantity and quality. Volusia County should be working to protect our water for the residents who live here now and not the growth industry. 7.1.8, alternate water supply. We have more springs than anywhere in the world in our county and in our state. Why would we look for an alternate water supply? Please vote no. Require answers to questions and a real plan for the ordinance. Thank you.
Thank you. Any questions for the speaker?
Not for the speaker, but it does bring up a question for staff.
Nobody for the speaker? Oh,
No, I'll just say thank you for your information.
Thank you. Mr. Fellow.
I guess you pointed out on B on page 40, pursue an increase in the CUP groundwater allocation. Is that, I thought we just, pardon my, I get lost in terms and I could be confused. So we are asking for an increase in the CUP or we are not?
That's an existing policy.
That's an existing policy.
We're not changing anything in terms of that particular aspect. So we're not asking for any new increases of an increase in the CUP. So if we asked for it and was granted, or if we asked for it and was denied, don't think we're asking again. There's nothing that in the comprehensive plan that we're changing where we're asking for more allocation for a consumptive use permit.
I believe I can also respond to the borrow pit question. Our utilities director responded that the pilot study at the borrow pit concluded last year. The study may have been a priority, but upon assessing potential recharge benefits with capital costs and other factors, an actual project is not occurring. He does understand that Orange City remains interested in the project for diverting stormwater from the river.
Any other questions for staff?
The only other question I have, and I'm sorry to say, and I should have started with this one, is this has nothing to do with reclaiming water and making it potable, correct?
No, there aren't even any rules for that yet.
I know there's not. I just want to make sure there's not. I mean, I tried to read everything, but there's nothing in here about reclaiming water. And
No, that's
okay.
Thank you. If anyone does it, it would be a very hard thing to do. I mean, there's rules that need to be in place. You know, then it's going to take a lot of permitting on the state level just to design something like that. So no, that's not on the table.
Okay, any other questions? Okay, we're going to close the public hearing and ask for a motion since we've had quite a few comments already.
I'm going to say this. I think that this should be reviewed by the NRAC committee as well too before it goes to county council. So I'm going to jump ahead of everything and make a motion if that's okay. I'm going to move that on case CPA 21-013, I guess I don't know how I would say this because I know there are things that have to be done, but how do I say that it would go to the county council with not a because there's no approval denial, correct? I mean, it's more of a.
Find it inconsistent.
Inconsistent with the, yeah, so find it inconsistent with the comprehensive plan, and then do I recommend denial, is that, or?
Just find it inconsistent.
Just find it inconsistent.
And I'll second your motion.
Okay,
Yeah.
thank you.
Now, in making a motion like that, should it be pointed out as to where it's been found, why we think it's inconsistent, so that you don't have to go through this whole document, or?
It should, just so we have guidance in the event we can fix those inconsistencies prior to going to council.
So I would point out that my testimony at that point would be the inconsistencies.
Okay.
Thank you.
And I would like to also bring Ms. Schreiber's comments on record also, make sure she made some very good points.
Okay, it's been moved that CPA 21013 be forwarded to the county council, being found inconsistent with the comprehensive plan. Okay, all in favor of that motion signify by saying aye.
Aye.
Any opposed? Aye. There is 1, 2, 3, 4, and 4 saying that it's inconsistent, and 2 in favor with Mr. Costa and myself. Okay, that is
So
done.
can I get clarification? So it's going to go to county council with finding that it was inconsistent from
Finding
the
it
board?
inconsistent.
Is that correct?
4 to 2.
Okay, thank you.
Right. May I ask staff, one, if it's not too taxing on you guys, I think we have about 3, maybe 4 more elements that's going to be coming before us.
Yes, sir, we have 2 more elements. One is sanitary sewer, which you continue today, and then we also have the future land use element.
When we get that future land use element, is it possible to get it maybe like 30 days prior to us having addressed it? Because this is quite a bit to digest in 4 or 5 days, in addition to all the other stuff and working. But if we can get that, so that if we have someone want to call us and discuss it and have conversations about it, it gives us time to deal with it, because this is kind of a cram for the exam that's coming up.
Yes, sir.
Thank you so
Can
very
I
much.
add on that? Trish, thank you very much I'm sorry that I was out of bounds in my, but I did do the same thing. I was like, where's our packet? I know there's some heavy stuff and I couldn't read it, and I didn't, so I appreciate it, but thank you. I understand the storm was maddening on all you guys.
Well, and just to clarify, so everybody is aware, we do apologize that you did not get your packets a full week in advance. All county employees have mandatory duty. We were on storm duty, we were on call center duty, and we were also on elections duty. So there was no one in the office to produce the documents that you needed.
Didn't understand that, and I thank you for that.
Thank you for that. Let's see, close commission discussion. We're gonna get to the end of this thing here. Okay, any more staff items?
No, sir.
Staff comments?
Mr. Chair, just a few things. So when you make email communications, if you have something, please email staff and not email each other directly.
That's the sunshine law.
Right, because if there's a two-way communication, like one of you accidentally hits reply all, that would be the sunshine issue. So if there's a communication, direct it to staff, and we'll be able to distribute it, potentially blind copy, so that someone doesn't accidentally, hit reply all, which is usually what would trigger that sunshine provision, because then you have that two-way communication. So if there's something that you would like distributed, give to staff, we'll be able to distribute it to the rest of the commission.
Great. Any other staff comments? Commission comments?
Just one. I wanted to thank you guys for working on the ADU issue. It sounds like it's making progress on that one, because I think that is a majority of some of the cases we're hearing. So I just wanted to say that I appreciate that you moved quickly on the ADUs for larger properties.
We are working on that right now. You have a very large January agenda now, and that may be bumped to February.
Thank you. And then the only other question I was going to have is, do we know a potential for the Southwest Activity Center?
Our plan was to bring that in January as well. It'll come as an all-day meeting. However, the first part will be just for the SWAC. The remainder of the day, after a break, will be for your regular items.
Thank you very much.
Good. So we meet one day for that. That was going to be one of my questions, was when are we going to reschedule that meeting? So.
Okay.
The weather's not
any other
cooperating.
commission comments?
The
Yes,
final
I'd
one.
like to,
Oh, sorry. I was just going to say.
I'd like to commend Mr. Bender on a terrific job today as,
Did a very good job.
as a chair, and
Yeah.
especially going through such a big packet.
But after Chairman Mills sees what January looks like, he may stay for longer. One thing else I'd like to say, it is so good to see Chairman Brower out there, because I was like the 8 years prior on this board and 2 here now. Thank you for staying involved. It just, you know, it's good to see councilmen and chair people staying involved in subcommittees and know what's going on. So
Absolutely. Here.
we thank you.
Boy, I was just getting, I didn't realize we had, I guess I was just getting ready to ask for a raise, so I guess the man.
Yeah.
But anyway.
Yeah. And yesterday was his birthday, so he takes presents afterwards.
Okay.
Jeff Bender, thank you very much. You did a great job today.
Press, citizen comments. None here. This meeting is adjourned.
Good.
Yeah.
But thank you, guys. Thanks for all your time.
What's that girl that used to, remember her? You're old enough to remember. What was her name that was the perfect?
Hey, don't call
the
my
movie,
buddy old. Come on.
Movie that was a perfect 10, remember
He's talking
that?
about you if you do.
Bo Derek.
Well, yeah, Bo Derek, that's right.
Yeah.
I never heard
I
of
met
her.
her before. She's
What happened to my pen, damn?
Okay, I'm supposed to sign these things, I guess. Do I sign these? Do I have to sign these? Is there something? Just leave them here? So I'm done? Great.
That was another one.
See you.